Court, first report. Here, all persons having business with the appellate will draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. Most of you are familiar with our practice. Please ask for the time that you need, not the time that you want. Understanding that we are fully familiar with your case, the briefs, and the record, oftentimes more than you wish we were. So, please do not get disturbed by the amount of time that I give you, cutting your time, because I want you to understand that the clock is for you, not for the court. So if you are brilliant and make arguments that keep my colleagues intrigued and asking questions, I allow the clock to continue, okay? All right. First case on the calendar, People versus Edward Williams. Okay. 4 and 1 and 4. Board of Managers versus 660 Columbus. Okay. 5 and 1 and 5. Trina L versus Micheline M is submitted. Guerra versus 100 Stevens Avenue. 4 and 1 and 4. Rodriguez versus Isabella, Geriatric. Let's do 6 and 2 and 5. Han versus J.P. Morgan. Okay.
Respondent requests 7.
Let's do 6 and 1 and 6. It'll probably end up at the number you're asking for. State of New York versus Anthony R. Okay. Let's do 6 and 2 and 6. Same rules apply. People versus Carl Dosier.
Appellate request 4 and 2.
Okay. 4 and 2 and 5. Needum and Company versus UpHealth.
Appellate request 7 and 2, Your Honor.
Okay.
Respondent request
7 and 2 and 7. People versus Reginald Tolliver is submitted. Weiss versus Park Towers South. Okay.
Respondent request
5 and 2 and 5. 5400 Company versus New York City Division of Housing. Okay, the appellant is not here. Do you wish to submit? Okay, thank you. Have a seat, and as soon as the calendar is over, you can step out, okay? Goine versus Nursistian.
5 and 1.
Okay.
And Appellate Meliar is 5 and 1, please, Your Honor.
Do you have a cross appeal?
We're concurrent appellants.
So that, you're what?
I believe that we are concurrent appellants, Your Honor.
Okay. All right, so you want what?
I would ask for 5 and 1, Your Honor.
Okay.
Respondent request 5.
Okay. 5 and 1, 5 and 1, and 5. Flatiron 30 versus Continuum Company.
Appellate request 5 and 1.
Okay.
Respondent request 5.
5 and 1 and 5. Shaba versus Family Home.
Request 7 and 3.
Go ahead. 3 and 1 and 4. You've been here several times. AJD Building versus Ben Harush. Okay. It doesn't, you don't need the 2. Do you need to argue, or would you like to submit? Thank you. Have a seat and wait for the end of the calendar call. And Martinez versus Urban Renaissance is a submit. First case on the calendar, People versus Edward Williams. Those who have submitted can now leave, if you like.
May it please the court, Abigail
Give me one
Everett.
second.
I'm sorry.
please.
Abigail Everett for Appellate Edward Williams. I'd like to address the appeal waiver issue.
Okay.
And I'm focusing really on the common practice of having the defendant do the factual allocution, admit under oath in court that he's guilty before the judge gets to explaining the appeal waiver.
Also, have you found any case law from this department that says that that procedure in and of itself is improper?
Not in and of itself, Your Honor. What the case recently of Nunez in this court, the court held that it wasn't, quote, dispositive that the court conducted the colloquy after the defendant's allocution. Now, it's not clear, but I take that to mean that it's not ideal, but under certain, when you view the record as a whole, that it may or may not be a problem. I would
So why, when we review this record as a whole, is it a problem?
Okay, I think you need to look at the individual person who's entering the plea and making the factual allocution. For Mr. Williams, we have somebody who has a drug problem. The record makes clear that he was on parole at the time of this. He was supposed to be in drug treatment. He was not in drug treatment.
Well,
He's
counsel,
also,
I think what is clear in this case is that this was a result of a plea bargain, right? And the court, at the beginning of the proceeding, sort of asked defense counsel if they've gone over the waiver of right to appeal, right? So there is an indication at the beginning that a waiver of right to appeal is part and parcel of this plea bargain. So what's the issue then?
well, a couple of things. One, when the court asked Mr. Williams if he had discussed this with his lawyer, initially he said no, which leads me to believe they didn't have a particularly memorable conversation about this appeal waiver.
Well, you said initially, what did he say
And
after?
then the court repeated it, and he said, yes, they had discussed it, but we don't know what was said. Now, the other thing I'd like to point out about
But we don't have to know what was said, right?
we don't have to know what was said, but if the court is going to infer that, really the case law says that the record on its face has to demonstrate that the standard of due process was met, and if the defendant initially didn't even remember having a conversation about this waiver, and I would also point out that he signed the waiver before the judge went to the allocution about the waiver. Again, it's the judge's obligation to make this clear. Now, the people, I believe, have cited Bryant, which is Court of Appeals case that this court referenced itself in Nunez. But when you look at Bryant, all Bryant said was, that's the common practice. You can see in Bryant that that's what happened factually in Bryant. But the issue in Bryant was something different. This court in Bryant had reversed because the court had not made it clear to that defendant that the waiver was separate from the guilty plea. So the issue in Bryant was not the issue I'm asking this court to look at. And I wanted the court to think of this from the perspective of a defendant in the courtroom. You come in, the clerk has you raise your hand, they uncuffed him, he raised his hand, he swore, quote, under God to tell the truth, and then the judge said, did you have the gun? He said, yes. Now, let's, to be realistic, how many people and he wasn't told that after I advise you of not only the constitutional rights you're giving up, but the appeal waiver, you'll be able to take that plea back and it won't be held against you. All he knows is in open court, he has admitted to all those people he had the gun.
Counsel, while what happened here may not be ideal, it's different from a situation where the defendant pleads, right, allocutes factually, and then is surprised that there's a waiver attached to this. That's not what happened here, right?
He was not surprised, but we don't know how much he understood about it. Again, I go back to the point I made before. This is a
But when you
drug
say
addict.
we don't know how much he understood, are you referencing at the time he made the factual allocution? Because I think the record as a whole, the judge does explain it, although later on.
Well, I think he has to understand it and make the voluntary waiver at the moment that he signed the waiver, not, that retrospectively the court looks at the transcript and says, oh, all the bases were touched eventually.
Okay, you'll have time
thank
on
you.
rebuttal. You may proceed.
Good afternoon, Your Honors. May it please the Court. Elliot
How
Hamilton.
do you address that, counsel, with respect to the sequencing? Isn't there a problem here with the sequencing here?
Well, to begin, no. And the reason why is that really at the beginning of the plea allocution, it was stated that the agreement for the plea was predicated on the waiver of the right to appeal. That's on the second page, line 20, that the court made it clear that it was clear on the record that there was a waiver of the right to appeal attached to this particular plea. And it should be noted, Your Honors, that this was definitely not the first rodeo for the defendants, for the defendant here with the gun case. Indeed, this was his fourth. This was going to be his fourth gun conviction in a matter of many years. He has been through this process before. He's a lifetime parolee. Taking the totality of the circumstances of this plea and the allocution, with the fact that he signed that he did ultimately sign the waiver. The waiver was also, the oral colloquy also modeled almost very much mirrored the model colloquy.
When did he sign the waiver?
He did sign the waiver before, but as this court has, but the totality of the circumstances would otherwise suggest that he was advised of his rights. He was advised that there was a waiver of the right to appeal attached to this plea itself, and we would submit that the totality of the circumstances with this defendant, as my adversary points out, really shows that an individual who is a longtime recidivist and a violent recidivist at that would have some knowledge as to the process that comes through here. Absent any other record that's developed, most certainly through a 440, we could potentially we can go into the question that my adversary points out that, oh, did the defendant really know exactly what was being waived when he ended up signing the waiver? We don't have that here.
Also, how do you respond to your adversary's position that by the time the defendant allocated factually, he was stuck now? Now there was nothing else to do but to agree to the waiver.
He could have filed a motion to withdraw the plea pursuant to Criminal Procedure Law Section 220.60, subsection 3.
But that's an after the fact issue. I'm talking about right there at that proceeding, right? When he allocutes factually, admits that the gun was his, and then he has to discuss the waiver.
Well, he had the judge ultimately gave him the opportunity, and he still decided to go forward, notwithstanding, and then went through the entirety of the oral colloquy, which again mirrored the model colloquy for a waiver of the right to appeal. And upon being fully advised by Judge Hornstein as to what he was waiving, he still decided to go forward with the execution of the waiver. I think, given this entire record, he validly and knowingly and intelligently and voluntarily waived his right to appeal. And as a result of that, all the challenges he brings forth in this brief are precluded from review from this court.
Thank you.
Thank you, Your Honors. We ask you affirm.
Counsel, you have a minute.
Excuse me. I would point out, with reference to the fact that Mr. Williams does have prior felony convictions, the record must demonstrate on its face that this was a knowing and voluntary waiver. We don't know what, if anything, has been said in other proceedings. And similarly.
But isn't that because your client didn't file a 440?
Well, I think that the case.
I mean, you can't make that argument and not have provided the court with what you are suggesting is missing.
I don't think it's the defendant's burden to make that record. I think the case law provides that when it comes to a waiver, both a guilty plea and a waiving the right to appeal, that the record on its face has to demonstrate that it's a known and voluntary waiver.
And
for
if
that
we think
reason-
that it is, then your failure to file a 440 is fatal.
Well, I would submit that under these facts as a whole, it is not clear that it was knowing and voluntary. Thank you.
Thank you.
Thank you, Your Honors.
Board of Managers versus 660 Columbus. You may proceed.
May it please the court, my name is Ali Hack. My law firm is Warshaw Burstein. I'm here today on behalf of the Appellate Continuum Board of Managers. And Your Honor, before we get into the substantive issues, I feel like it's important for me to set the framework. We're dealing with a 3211A1 motion by opposing counsel. When we're dealing with very lofty standards here. The courts that have set the precedent here have required that there be no alternate interpretation of the documents in order for this kind of motion to be granted. They've used words such as conclusively establish, utterly refute, unambiguous, undisputable, no reasonable view of the facts that would favor the non-movement.
Well, what's your view? Why do you believe that Supreme Court got it wrong?
Well, Your Honor, good question. So in response, in my opposition to his motion, I brought to the attention of the lower court 8 different sections of the condominium documents that show assessments and common charges being discussed in the same clause. Council's position is that no, there's no such thing as assessments. Everything's a common charge. But how can that be possible when you have the two terms side by side? The case law is clear from this very department that says that when you have terms side by side, they have to mean different things. So that was the lower court's order.
Is that what our case law says?
Yes, Your Honor.
Okay.
So, and the lower court didn't even discuss the sections that I raised. The council didn't address them, the lower court didn't discuss them. So that's why we took this appeal, because we wanted to bring to the court's attention that there are these other sections here that validate our position that there's such a thing as assessments, and they cannot be treated as common charges.
Let's be a little more specific. We're talking about facade restoration, correct?
Yes, Your Honor, local law 11 work.
Refurbishment?
Yes.
How is that defined under the declaration?
How's that defined under?
Under the declaration?
Well, you're asking how?
Isn't it defined as a restoration, repair, replacement, and rebuilding? Wouldn't that fall within the definition of 1W?
No, Your Honor, because you can't lump a major $1 million renovation with.
How much is irrelevant? So speak specifically to the language that you are relying on, counsel. I think that's what my colleague has asked you. You're speaking in very general terms, and that's not going to win the day.
Okay. So the language.
I'm sorry, go ahead.
Go ahead, Your Honor.
No, what I'm trying to understand is when I look at 1W, it talks about restoration, replacement, and rebuilding, and that's precisely what you're doing here, correct? The facade work and the roof refurbishment would be restoration, replacement, and rebuilding.
Yeah, but that doesn't necessarily make it a common charge, a common expense for a common charge, Your Honor. That doesn't necessarily make it a 2.4% rate that gets billed back to the.
So tell us where in the documents it means something else.
Well, assessments, special assessments are not defined.
So general. So you're saying, the board has the absolute right to generally decide that there's going to be a special assessment of $1 million or $2 million because
yes,
the building needs work.
Under sections, Your Honors, under sections, bylaws section 5.1, declaration section 5, even 1C of the bylaws which council relies on, those give the board the right to determine what's a common expense. And so we determined that this $2.8 million repair cannot be a routine repair and renovation billed under common charges. This has to be a special assessment because it has to get billed, for various public policy reasons, it has to get billed specifically separate from what's a common charge. And so the public policy behind that is because, you can't have these one-off major
This is, I'm sorry.
Yes, Your Honor.
The fact that buildings over time have to have roofs repaired is not an unusual occurrence. So why that would not be specifically outlined and referred to in the documents is beyond me.
Well, Your Honor, the documents are ambiguous. That's our point. There's no one way to interpret these documents.
How are they ambiguous?
Because the documents have assessments and common charges discussed side by side. But council's position is that everything's a common charge. Well, what's an assessment then? Why is the word assessment?
Well, everything, it's possible that this could, in some buildings, be an assessment, but in this particular building, under the documents that control this particular condominium, 1W seems to include all the work, and I don't find it very ambiguous, as Judge Singh said. Restoration, replacement, rebuilding, those are all in this building considered common charges.
So what's an assessment? That begs the question, what's an assessment? It has to be something special.
Well, this doesn't seem to be it.
That's right. The documents are ambiguous for sure. That's why we need to do a deep dive. Also, the budget, Your Honor, the first year budget shows repair and maintenance. It's on record. I'll get the record reference. 785. The first year budget shows repair and maintenance. It budgets $80,000.
Wait a minute. You want us to refer to a first-year budget instead of the documents underlying the building?
No, it shows the intent of what repair and
Counsel,
maintenance means.
you understand that we don't go to extrinsic evidence unless we find that the documentation and the terms in the contract are ambiguous, and you have not established that. But since you've run out of time, you can try that on your rebuttal time, okay? You may proceed.
Good afternoon, Your Honor. Robert Abrams with the firm of Katz & Corrins on behalf of Respondent.
Counsel, how do you respond to your adversary's position that the term assessment is not appropriately defined in the documents?
Well, the term assessment is actually set forth in Article 5, Section 1C, and that is the dispositive provision. It says, "The board shall from time to time and at least annually prepare a budget to meet common expenses," and that is the facade restoration project, "and shall allocate and assess to the unit owner's charges, defined to mean common charges, meet common expenses in accordance with the provisions of the declaration and Exhibit D annexed thereto." And what's important there, Your Honor, is that I emphasize that the section doesn't say Exhibit C annexed thereto. Exhibit C is the schedule of ownership interests, which the board is trying to use to calculate how much we owe. It says Exhibit D. Exhibit C is nowhere implicated. And to answer Your Honor's question about this facade restoration being a common, expense, Section 15C specifically says that repairs to the portion of the exterior walls and facade of the building shall, I'm paraphrasing here, shall be treated as a common expense. It says right there in black and white. Now, the board has, there are other provisions as well that further buttress this point, which are in our brief, but I wanted to address a few points that they raised in their reply, because what they're saying in their reply, they're trying to add words to this contract by saying, well, Exhibit D really doesn't apply because Exhibit D really only applies to routine repairs and maintenance. But the word routine appears nowhere on Exhibit D. Am I out of time?
Oh, you still have time.
I'm sorry.
That light would go red if you ran out of time, okay?
So the word routine appears nowhere on Exhibit D. Similarly, they're trying to say, well, the board didn't try to say that the word all does not come before the word repair and maintenance. So therefore, there's some wiggle room to say that this facade restoration project is somehow excluded from Exhibit D. There's no limiting language at all on Exhibit D. And lastly, Your Honors, as I'm sure you saw in the reply, they actually tried to define the word assessment in their reply papers. They crafted a brand new term, defined it as the definition, asks this court to adopt that definition and embed it into the contract. Obviously, Your Honors, this is a violation of the tenets of Vermont Teddy Bear.
So what provisions authorize the board to impose assessments? Article 5, for example, Section 13 talks about additions, alterations, improvements in excess of $500,000.
Right, that's
Would that-
Section 13. That actually buttresses our point.
But that's what I'm asking. Would this facade work, why wouldn't this facade work fall within that provision?
It does. It absolutely does. The board, and that's one of the arguments I certainly raised below, and I raised here as well, that Section 13 of Article 5 does apply. And that also talks about assessments.
And what says shall be
circles back
assessed
into-
as a common expense.
I'm sorry?
It says as shall be assessed as a common expense.
Exactly, which circles back to Article 5, Section 1C, which says, as I just read to you, that it is deemed to be a common charge, and Exhibit D to the Second Amendment applies, which takes us back to Section 20 of the Declaration, which contains the formula. Thank you.
Thank you.
So, Your Honors, my attempt to craft a definition was my attempt to harmonize the various provisions of the condominium documents, which under the standard of this department, the lower court was supposed to have tried to have done when it sees assessments and common charges in the same place. It's supposed to have harmonized, and that's what I tried to do. If Your Honors find it persuasive, great. Then now we have a definition of assessments. Finally, a formal definition.
But
If
why
not,
wouldn't we look at the documents? So, for example, what we were just talking about, Article 5, Section 13, which talks about additions, alterations, or improvements in excess of $500,000 shall be assessed. But then it goes on to say it's common expenses. Doesn't that support your adversary's position?
Well, it's a common, so how does he get that under Exhibit D then, to get a 2.4% common charge rate for this particular charge? Council wants you to take you under Exhibit D under the repairs and maintenance section, but he never defines what repairs and maintenance are. He faults us for not defining assessments, but he gets to make repairs and maintenance mean whatever they want to mean. That's not fair. He has to define what is a repair and maintenance. Is it painting the hallway, or is it a $2.8 million facade repair? And in common practice,
I thought Section 1W defines what repairs are.
it defines what repairs are, but doesn't necessarily mean that they're a common charge repair. It could be an assessment repair.
Okay.
So that's the difference here. And Your Honor, I wanted to just real quick direct your.
I'm going to give you 30 seconds because
30
as you see, your light is out.
Yes. So Section 2B, Article 2, Section 2B, connects assessments with compliance with applicable laws. Section. Secondly, the CEO, the commercial owner, never explains where or how they got the court to Exhibit D, which I just said. Thirdly, Note 4 gives 4 possibilities on how they're going to raise money for extraordinary repairs, and leveling assessments is one of them. Common charges is not one of them. And finally, Your Honor, when tasked with determining the meaning of a term in a writing, New York courts frequently refer to common practice. And every condominium I've ever been a part of has assessments and assessments and common charges, and never the twain shall meet. There has to be, for public policy reasons, a distinction between the two.
Thank you. Guerra versus 100 Stevens Avenue. May proceed.
Good afternoon, Your Honors. May it please the Court, Irina Kravchenko, I represent defendant appellant on this appeal. It is the appellant's contention that the motion court erred in denying its motion for summary judgment. The facts are undisputed that there is absolutely no defect in the door or the landing.
Except that a door should not swing out beyond the landing, because that in and of itself is a dangerous condition.
Your Honor, it is the appellant's position that the width of the landing was not a proximate cause of plaintiff's accident. Based upon her own testimony, she indicated that she grabbed the handle, opened the door.
All she said was there was nothing wrong with the handle, right?
Right.
That there was no defect of the door, but that's not what we're talking about. The problem is that this door opens out into the street instead of pushing in, and the landing in front of that door is narrower than the door.
Yes, Your Honor, that is the case. However, the cause of the accident was plaintiff when she opened the door hitting her, not the width of the landing.
So your argument,
But the reason it hit her is because there was nowhere for her to move to without falling off the step. So that's not inconsistent at all with the defect that Judge Mansonet described.
Your Honor, there's absolutely no evidence in the record that plaintiff could not have stood off the landing and opened the door.
Well, in this particular case, the plaintiffs did put in with their opposition papers an expert's opinion explaining the problem with the door opening the way that it did. Even though there was no code violation, we understand that. That's not the end of the inquiry, and that it would have been very hard for her to open it up. It comes to her, how's she going to get into there? Now, you may be able to prove that's not the issue, that's not what caused her accident, but that's at least raised an issue of fact. You did not put in any expert affidavit to counter that.
Your Honor, it is the appellant's position that the expert's opinion is misplaced in this case because, as you indicated, there is no code violation and plaintiff's expert didn't state.
But there's no
a
code
custom
violation because this building was built before Mount Vernon had any codes. So that doesn't help you.
Yes, Your Honor, but there is no retrospective application of the new code, which means that legislation.
But that
didn't
does,
attend.
but there can still be negligence even if there's not a violation of the code.
Absolutely, Your Honor. It is the appellant's position that the analysis is based upon the facts application to the legal precedent, which in this case, it is not a defect. This court's decision in Hinton versus City of New York, 73-83-407 in 2010, illustrates the point. The plaintiff fell off of a loading dock, and they showed evidence no prior.
Well, loading dock, that's not the same as entering a building with a step that is not wide enough to accommodate the door that's opening in front of it. Totally different.
Your Honor,
Totally, okay?
it is the appellant's position that it is comparable because there haven't been any complaints for 2 years at least that my client was in possession.
And we know that's
importantly-
irrelevant, right? The fact that someone hasn't complained, the fact that someone hasn't fallen before doesn't prove anything.
Your Honor, this court in Hinton did rely on the lack of prior complaints in the situation where there is no notable defect. In other words, that you
Here, there
cannot-
is a notable defect, namely that the door opens out onto a landing which is too small for the door to fit, so the person has to step backward or fall or get hit by the door. So it seems to me that that's the very issue, is that there is a noticeable defect. But I wanted to go back to what you said about the expert report. You seem to suggest that you didn't need to put in an expert to counter plaintiff's expert because there's no issue about a code violation. Why would that be the only issue for which you'd want an expert?
Your Honor, I see my time is up. May I reply?
Yes, of course.
Thank you. In this case, because the plaintiff indicated that there's no code violation, and in addition to that, the plaintiff's expert did not specify that any kind of custom or practice or industry standard has been violated. So therefore, he's opining about an issue.
Except that the expert did provide about 3 different suggestions of how the landlord, building owner could fix this problem. Either you push the doorway in, or you extend this platform out so that it is as wide as the door. But you'll have time on rebuttal.
Yeah.
Good morning, Your Honors. My
Good
name
afternoon.
is Gennaro.
Afternoon.
Good afternoon, Your
It's okay, it happens to me too. Go ahead.
My name is Gennaro Savastano from Eleftheratis and Panic, representing plaintiff Nancy Guerra. Justice Hadler got it right here. There are questions of fact, and I just need for a moment to preserve my client's integrity because there are disparaging remarks made and characterizations about her testimony where defendants say that she was basically tapped by this door, and that's not what the record supports. I mean,
She falls back and ends up unconscious.
exactly.
We saw the video, yeah.
Yes.
I'm sure you did. I'm sure. So, Nancy Guerra was a cleaning lady working the night shift. She was testifying through a translator, and they're trying to spin it as though, this was just a little tap and she caused it, and, needed the wrist surgery for nothing. So now that I've gotten that out of the way, there are a couple of mischaracterizations that I think this court already sees given your line of questioning. Defendants would love to have to frame the issue as just the length of the door over sweeping the landing by 5 inches. Yes, that is a critical element. It's one of several. The landing was only 20.5 inches deep. I'm not relying upon the code, but under the code, it would have to have been 44 inches as of today. So you can, on the one hand, say, oh, my building is 90 years old, so we don't have to comply with the code. And also, don't pay attention to the code, and don't pay attention to plaintiff's expert, who says, contrary to my very able adversary's allegation, in paragraph 3 of his affidavit, he specifically says he considered industry custom and practice to make his determination, which was based on all of these factors. The last of which is not least the lack of warnings. It's undisputed that there were absolutely no warnings. My final point would just be that grandfather clauses such as that in the building code are not shields to common law liability. You cannot hide behind grandfather clauses from the common law. So unless the court has any questions, I'll yield my time.
Thank you so much. I'm going to give you his extra 30 seconds. Go ahead.
Your Honors, with respect to the expert, it is the appellant's position that he usurped the role of the court in this case, because this issue is not technical knowledge, it is not specialized knowledge, which is why his conclusions to the ultimate issue of the case, yes, this was dangerous, should not have been considered, should not be considered, were absolutely improper. And with respect to the failure to warn, plaintiff, as my counsel, the co-counsel admits that, plaintiff's counsel admits, plaintiff has been to this building many times. She's been there 5 days a week for the past 3 years. So
Isn't that a matter of comparative negligence at best?
I'm sorry?
Isn't that a matter of comparative negligence at best?
You want to, I was making that comment with reference to the failure to warn, now that there's no proximate cause, because she was aware of this situation with the door and the landing. Unless the bench has any questions, I'll rest.
Thank you so much.
Thank you.
Rodriguez versus Isabella Geriatric. You may proceed.
May it please the court. Good afternoon, Your Honors. Joanne Horowitz for the plaintiff appellant, Cynthia Rodriguez, administrator of the estate of her mother, Luz Rivera. As you all know, this is an appeal from a granting of summary judgment to the defendant on a nursing home negligence case.
Counsel, could you address what in the expert nurse's affidavit establishes her qualifications for opining on this subject?
She is a very highly qualified long-term nurse, registered nurse, who has worked in many settings, hospitals. She's as well as with the visiting nurse service, which she specifically stated in her affidavit that she had experience with nursing home patients such as this particular decedent.
In that period of her career lasted, as I recall, about 15 years?
Yes, 15 years. And the visiting nurse service, I might add, is she specifically references doing care plans for nursing home patients. She is not at all someone who is not familiar with elderly or dementia or anything like that.
Indeed, part of her specialty is in assisting in the creation of plans for at high risk patients who are susceptible to falling.
Correct. Correct.
Which is precisely what we have here.
Correct. And as Your Honors saw, this isn't a one-fall case. It's a many-fall case.
At least 15 times.
So how does the affidavit or the opinions of the nurse raise an issue of fact as to the standard of care in this case?
Right. The nurse raises a number of issues of fact on the standard of care. She pointed out in her very long, incredibly long affidavit, the many different failures. Now, counsel will say that she can't opine on one-to-one supervision, though I will note that one-to-one supervision was available because they used it at a certain point. And some of the cases are in not using things that are available. She could also, she could opine on who's a high risk or not. Now, the respondents' records are replete with references to this person being high risk for falls, yet the care plans only put her at medium, although they're...
And did that designation of medium risk change during her stay after falls that required surgical repair with internal fixations?
Never.
She had at least 2 breaks of her femur. Did that change? Did that fall designation from medium to high change after those falls?
Never. The care plan was always medium. The testimony from the nurse was that she was perceived as high risk, but the care plan didn't change. And I might point out...
And upon admission, this was a patient who had already been diagnosed with dementia, correct?
Correct.
And so it seemed, based on my review of the record, that the defendants were relying on her ability to follow instructions
Correct.
for someone who might not even be able to remember what the instruction was 2 minutes after you give it.
Yes, Your Honor, and there was testimony from the plaintiff that her mother, unfortunately, because of her dementia, she would, nod, but she couldn't re-demonstrate. She wouldn't like.
She wasn't even asked to do that. I mean, the record didn't reflect that anyone ever said, okay, can you push the button?
There may have been, and because I don't want to mislead anybody, there may have been testimony that she was asked to. She may have been asked to. The testimony, which raises a conflict, is that she wasn't able to.
And we know this because on at least 6 occasions, this woman was found on the floor, in the bathroom, out of her bed, in the middle of the night.
I can't say how many occasions, Your Honor, she was that way. I know for certain one of the big ones was out of bed on the floor in the bathroom. Another one was out of bed on the floor near her bed.
And she couldn't answer as to how this accident happened. She wasn't able to respond.
Right. And another one was, in her bed saying, I fell out of bed. She's back with the laceration. We believe, and putting aside even, because I don't want to lose the ordinary negligence claims, because the court below focused solely on the issue of whether or not the nurse was qualified on a medical malpractice basis. I don't want to lose, first of all, I would say that this was a nursing standard, which she is eminently qualified to testify about, but I don't want to lose the ordinary negligence factor that the court below overlooked, and which we've talked about. Oh, sorry.
Thank you. You may proceed.
Thank you, Your Honor. Good afternoon. My name is Lisa Fleischman. I represent Isabella Geriatric Center. Your Honors, the expert here was not qualified to render any opinion whether malpractice.
Why not?
Because she has never worked with dementia patients. Your Honors have mentioned dementia numerous times on this bench in this argument. She's never worked with dementia patients.
That's not what she said.
She said geriatric assessment care. She didn't say how, when, where did she get that experience, for how many years, what did she do?
But doesn't that go to weight, not admissibility? That degree of detail, it doesn't preclude expert testimony. That may be, if you ever get to trial, that's a issue you could argue, but that certainly isn't a basis for excluding her testimony as expert testimony completely.
I submit that it does, Your Honor, because these are claims that arise within a nursing home, which is regulated by a certain
But she
type.
testified, but her CV shows that a major part of her work for more than 15 years was developing care plans in nursing homes, and I submit that a large number of the residents in nursing homes would probably have some level of dementia, so I think that's sort of implicit in the care, isn't it?
Well, that was one
And
thing.
in geriatric care.
Yes. But
I would imagine that if you speak with people in the profession and ask them what percentage of geriatric patients are exhibiting some sign of dementia, it would probably be about 80%.
it may well, but it's up to the expert to lay a foundation, to explain how she has the basis to render an opinion, and it's
But
not.
isn't it enough that she has the experience in dealing with patients that are high risk, irrespective of why they're high risk?
Why high risk? What high risk? It's not
Of falling,
here. She
high
doesn't
risk of
say
falling
that.
and safety
Counsel, she went into your client's facility after a fall, after being found in her home unconscious, having a fracture of her left femur, which she fractured again in your hospital.
Right. Those are the facts, Your Honors. I submit to you that this expert was not qualified to opine as to the issues here.
Okay,
But counsel, why in fact
if we disagree with you, what else do you have?
Her affidavit, if you find that she was qualified, was utterly inadequate. It was completely conclusory.
To the contrary, it was extremely detailed, far more detailed than your expert's affidavit.
Oh,
I actually have a simpler question, which is, The record didn't include any care plans executed by your client for 2014 and 2015. Why isn't that prima facie evidence of negligence?
Because the record shows that the things that were put in place with respect to the other care plans
But
were
how do we know what happened in 2014 and 2015 if there was no care plan whatsoever?
Yeah, that was not included in the motion
No,
record,
we
and
don't-
I can't speak to that, Your Honor.
Well, you have to speak to it because you're their counsel.
What I
How
can say-
Why can't we draw an inference in the fact that there's no care plan at all in the record for those 2 years?
You could draw that inference from the fact that in the record, it shows that the fall risk or fall prevention interventions were in place throughout her entire stay.
We don't know that they were in place in 2014.
And they didn't work.
Yes, we cited
She fell out of her wheelchair 6 times. She fell out of her bed at least 3 times with fractures requiring surgery. We're not talking a little bump on the head, okay? It is amazing this woman didn't die from one of those falls earlier, okay? And nothing is changed. I don't understand how someone falls out of a bed, fractures a leg, and there is no change to the plan. None.
No, that is not true, Your Honor.
Tell me where in the record it changes from her intake. Please show me, because maybe I missed it.
Our expert testified that every time there was a fall, there were changes to the
Tell
care
me
plan.
where in the record
Want me to look it up?
shows
I
that
will
the plan
take the time to
actually
look it up.
changed.
Especially in the absence of a care plan at all for 2014 and 2015.
I went through the record. I couldn't believe this record.
Your Honor, every
She
time.
fell more times than I can't even imagine.
Well, according to your own records, she fell at an average of once every 3 months.
Yes, Your Honor, that's correct.
That would
She did.
necessitate a change in something, right? Once every 3 months?
And they did. The changes were made after
well,
every time.
where are the
Where
plans?
is that shown in the record?
If you want me to spend 10 minutes here pulling up, I can send a letter to the court explaining those
No, we
citations.
expect you to know your record, counsel. We want to know where in the record it shows that they did anything after she had all these falls. None of us could find anything.
Exhibit S, I don't have the record citations, show that there were care plan updates that were made. She was moved to the
Also,
dementia
saying that there were
unit.
care plan updates that were made and then showing the updates themselves are 2 different things.
Then I'll refer the court to page 47 of my brief, which cites to areas in the record that show that the low bed, the mats.
Look, I appreciate that the center attempted to put into place what they normally do with someone who's high risk. A low bed, mats on the side of the bed in the event that they get up, right? I get it. But counsel, how many times does a patient have to fall and get seriously injured before something changes? Clearly, this woman was incapable of following instructions.
May I respond, Your Honor?
Yes, that's why I asked the question.
Okay. The goal is to reduce the risk of fall. It can't be eliminated in a dignified, humane way. We can't strap down.
What is dignified about falling out of a bed and breaking your femur every 3 months? I mean,
you have
right? So I don't want to tie her up. I get it.
or drug her.
Or drug her.
Yes.
But I don't know. There has to be a system that can alert the desk, move her in front of the nurse's station so that if someone sees her attempting to get up, seeing as she's broken her leg several times. None of that was done here.
Well, they did move her for close observation.
No, they only moved her during the day in a wheelchair in front of the nurse's station. At night, which is when all of her accidents occurred, right? All of those nighttime accidents with broken legs, that all happened at night.
And they did
in a room not close to the nursing station.
And they did frequent bed checks. She had a wander guard. They did everything that they could, short of tying her down.
Well, they could have had I'm sorry.
Go on.
I understand it's a difficult situation. Couldn't it be, as the nurse suggests, that given all the falls, all the injuries, if your facility was incapable of really providing her the adequate, proper services, that she should have been transferred out to a facility that could provide those services. Isn't that an issue that a jury could consider, assuming that the nurse's affidavit is sufficient?
Well, Your Honor, we presented evidence through our expert that bed alarms, it's an alarm-free facility. Isabella.
But your facility may not have been the right place for this person. That's what the nurse is saying. Isn't that an issue for a trier of fact to consider?
I would submit that the plaintiff kept her mother there for 3.5 years and knew it was an alarm-free
So
facility.
there's comparative negligence on the part of the family?
I'm not going to go so far as to say that.
Oh my God, that argument was like, you should have taken her out of our place. It's your fault. That's what you just said. Thank you.
Your Honors, I'd just like to note, once again, there are numerous questions of fact, and about the given the number of falls, the inferences are negligence from the records, and the fact that the records even question whether the mats each time were there.
Counsel, what is your position as to whether some of your claims sound in ordinary negligence as opposed to medical malpractice?
Yes, yes.
What is your position on that?
What my position is that they do sound in ordinary negligence, many of the claims. For instance, the issue of...
In fact, your expert said it beautifully in her affidavit. This is common sense.
Thank you. Thank you, Your Honor. It is common knowledge, and I think I'll rest on that.
Thank you. Hand versus JP Morgan Securities. You may proceed, counsel.
Good afternoon. My name is Daniel Rubens. I represent the appellant, JP Morgan Securities. May it please the court. The Supreme Court erred in confirming this $2.5 million FINRA arbitration award without respecting our statutory right to challenge the award for manifest disregard of the law. Manifest disregard is, of course, a high standard, but that's not a reason for a court to decide that question.
Well, but before we get to manifest disregard, the statutory limitation period you're talking about, both federal and state, is that a stay provision, or is that just a provision saying that you have to act within a certain period of time?
It's the latter. The stay provision comes from FINRA's rules, which is why one of the reasons we had to file within 30 days to stay the award. We also had to respond.
Well, that's a separate issue. I'm talking about, just address yourself to CPLR 7511.
Yes.
Does that give you the entire time to file additional submissions, as I think you're suggesting?
It doesn't necessarily. When there's a quick petition to confirm here, then we certainly have an obligation to oppose that, and that's why we're in the situation we're in now. He moved very quickly to confirm the award, and we were on the clock to oppose it. We also had this obligation to file a motion to vacate to stay the award, and that's why we were in this scenario where we didn't have the transcript.
Well, how would the transcript then address the issues with respect to the manifest disregard of the law?
Well, I think that the definition...
Because you were at the arbitration, so you know what happened.
I do.
Right? And so while clearly one could use a transcript in order to quote precisely something from the record, it's not like this was an arbitration with someone else and you weren't there, right? So you know, and I presume counsel who was present and whatever assistant was sitting with them was taking notes about what was happening during the arbitration. So I don't understand this argument that I'm incapable, I need 90 extra days, right?
Well, what's important here is that the legal arguments were made in closing, so they were made orally at the arbitration. We were very clear with the court about how we proposed proceeding. We didn't think that you could lay out the case for manifest disregard just based on a recollection of what legal arguments we made. We thought it was very sensible to just do that based on the transcript. We didn't want to delay this indefinitely, that we used the 90 days as a benchmark. If the court had wanted us to move more quickly once we got the transcript, we would have been happy to do that, and we're prepared to do that. To get back to Justice Singh's question and how it would have helped, in addition to the fact that the closings and the legal arguments were oral. Take the defamation claim. It's based on a statement on the Form U5. We don't have that on the record. It's not before this court. It wasn't before the Supreme Court. One of our submissions is
You never had a copy of that?
I have it. It's just not.
So then, I don't understand why you're making that argument. If you had a copy, you could attach the copy and explain you didn't have the record, right? I mean,
Yeah, but part of the manifest disregard showing is that we have to explain how issues were presented to the arbitrators. So we didn't want to do it piecemeal by relying on what we had in exhibits and saying, well, here's what we want to show for now, but we want to supplement this by also showing how it was presented and how the arbitrators received it, which is inherent in the manifest disregard showing. So that was the problem. We were very clear in previewing the grounds we were going to argue in the papers we put in opposition. My adversary accuses us of relitigating the facts and arguing manifest disregard of the facts. And that's not what we're doing. I mean, we of course disagree on the facts, but we don't think they have a claim on defamation and on wrongful.
well, so that now that turns on what law is applied, right? So you want to address what your main argument is as to why there was a manifest disregard?
Well, I do. I mean, to be clear, our preference would be for this court to send it back, but I'm happy to speak to the argument, which is there's an operative controlling choice of law clause in the agreement that specifies the arbitration should be conducted under the laws of the state of New York. And New York has...
But did the arbitration agreement say anything about what substantive law would apply, for example, with respect to defamation claims?
Well, that's what that provision is saying.
And if it didn't, how can we reach the conclusion that what the arbitrators did, while it may be legally wrong, was egregious?
Well, saying that the arbitration should be conducted under the laws of the state of New York is a substantive choice of law clause. The U.S. Supreme Court has said that in the Master of Bono case and a similar provision. And New York, I know there have been some arguments about public policy. New York has a public policy that there's an absolute privilege in the Form U5.
So isn't it possible to interpret that clause, shall be conducted under the laws of the state of New York, as meaning procedure rather than substance? And if the arbitrators did that, then their action is not egregious?
I don't think so, because it separately says that its arbitration is under FINRA's rules, so those are the procedures. And I don't know why that clause would refer to conflict of laws principles if it wasn't talking about choice of substantive law. But even if the court were inclined to think there's a manifest disregard problem on this point, it's still the truth point is an independent ground for challenging the defamation claim. Our submission is that the statement on the Form U5 was literally true. Even the dissenting arbitrator talked about how it referred to allegations and was framed in as least damaging as it could have been. And we have an obligation under the FINRA regulations to be reporting the reasons for a termination. So we got a report of a suspicious transaction. We investigated it. We disclosed it in a way that we thought we needed to in describing it. And I just don't think that...
Now you're referring to the alleged?
Yeah, right, which is all that is in the record now about the content of that statement. And I think we're really not asking for a whole lot here or below. We just wanted a chance to put in the one brief kind of...
So what case law supports this? It's not so much manifest disregard of the law, but essentially what you're asking us to do is to agree with the dissent, which I agree is a strong dissent, as opposed to what the majority found.
Well, I think it's just baked into the manifest disregard standard. We're not saying that because there was a dissent, therefore the award is in manifest disregard. The dissent, in addition to identifying factual things it disagreed about, it identified errors of law. And all we're saying is that on a full record, we should be allowed to discuss the errors of law and how they were presented to the arbitrators so that a court can evaluate it under that standard.
Thank you.
Good afternoon. My name is Blaine Bortnick from Roscoe, Clark, Perez, and Nieto, and may it please the court. I want to address a couple things.
Counsel, why wouldn't it have been reasonable to allow a delay so that they could put in their brief together with based on the entire record?
They had the transcript prior to the time they filed their reply brief. They could have asked for additional time to file the reply brief. They never did. The actual official transcript is not the transcript they're talking about. The way it works is it's a recorded transcript. It's made available to the parties immediately. It's posted on the FINRA website, and then the parties work together to hire a court reporter to go ahead and translate it. So they actually had the audio right away.
So they had the audio transcript from day one?
Day 2 or 3. I'm not day 1.
Sorry.
Yes, immediately. And then the parties, we worked together and we said, okay, we'll get a court reporter, we'll split the costs, and that's what we did. So any arguments they wanted to make, they could have easily made it by reference to the tapes, but as we argue in our brief, that's completely irrelevant to the manifest disregard of the law.
So why don't you address that?
Okay.
Because that does give
Sure.
me some pause.
Sure. No, well, there are a couple of, there are several bases they want to make it on, but let's talk about the defamation first, keeping in mind they have to prevail on all three, any one of the
Let's
three
just
grounds.
deal with the defamation.
Sure.
They applied
Okay.
New Jersey law, not New York law.
The manifest disregard of the law standard, and there's no dispute here. It's a pretty high standard to meet. The arbitrators have to be made aware of a governing legal principle, and they refuse to apply it or ignored it, and the law was well-defined, explicit, and clearly applicable. Well, who presented the law to them? Only Mr. Hahn. We're the only side that actually briefed it, and that's in the record on this choice of law. And, you know, despite the fact that this confidentiality arbitration, agreement has an arbitration clause, we said that's just governing the conduct of the arbitration itself, but as a matter of substantive law, and we cited case law, and it's also in our brief, that you have to apply New Jersey law. They never said boo in response to that. They had plenty of time to brief it.
Why would New Jersey law apply to this arbitration agreement with substantive law?
No, just on the defamation.
On defamation.
Just on the defamation. And it's, I can turn to that in our brief, but we actually brief it very well under the choice of law. With respect to defamation, it deals with, generally speaking, I'm giving you a broad brush, where the harm occurs. Mr. Hahn lived in New Jersey. The harm occurred in New Jersey. Therefore, under a choice of law analysis, which we briefed, that New Jersey law has to apply to the defamation.
So in other words, even if the arbitrators got it wrong with their choice of law, it's not manifest disregard.
That's right, because the other side didn't even present it to them. So you don't even get to the point of, doesn't, if they're wrong, it certainly, it can't be manifest disregard if only one side's giving them the law. That's how my understanding of manifest disregard of the law works.
What about manifest disregard of the fact that
That's not a basis, and I can tell you, there are a lot of times throughout my career, I wish I could have argued that. That's arbitration, that's the rules we live under. I do want to raise the issue, though, on the petition to vacate. And as we point out in our brief, that is a very important distinction. Normally, it's two sides of the same coin. For the reasons we pointed out, not so here. The petition to confirm is required to clear his industry records so that he can go and get his job. The petition to vacate, if that doesn't exist, J.P. Morgan has to pay right away. And there are considerable damages here that the panel found. It's crystal clear. The Court of Appeals said, and I've never seen a Court of Appeals case with all caps. Those are not my all caps in the portion we quoted. It's the Court of Appeals that, you can't just rely on CPLR 2001 to say, oops, we made a mistake here. This was pointed out to them almost a month before the lower court heard argument on this. And they still had more than a month from that time within their statute of limitation to fix the problem. We said, you never filed a petition. They never even filed an answer to the petition to confirm, but they never did it. There was no hiding the ball here. It's absolutely and positively jurisdictional in this. So there is no petition to vacate. So there's no basis for the appeal whatsoever on that aspect of the lower court's order. Similarly, some of the other points, such as the joint employer doctrine, we're the only one that briefed that, and we said, look, this is a joint employer doctrine situation. In fact, the U5, the defamation, comes from the appellant here, J.P. Morgan Securities. They're the one that's responsible for the industry record U5. Other terms and conditions of employment, their argument would be it had to come from the bank, which is not subject to arbitration, but we pointed out it's a joint employer doctrine. Again, we're the only ones that briefed it. The arbitration panel had full authority and ability and discretion to make an award against J.P. Morgan Securities. And there can't be any argument on the defamation. Unless the panel has any other questions, I don't think I have anything else to say at this point.
Thank you.
I want to address the cross-petition point, but very quickly on the main issue. I mean, my adversary is repeatedly referring to us not having briefed things. I think that shows why you needed the transcript. As I explained, we made our legal arguments orally in closing, and we agreed to split the transcript, recognizing that that would be important for the proceedings in Supreme Court. That's at page 139 of the record. On the cross petition, we did file a cross petition. That's page 40 of the record. I think my adversary's position is that that wasn't an adequate document, and it's true that it's short and attached to other papers we filed, but we filed
It's bare bones, right?
it was bare bones. But this,
And you were doing that presumably because you were running out of time and you wanted to put something in there.
to comply with the FINRA rule about staying the award. But I want to refer the court to the Joan Hansen case we cited in our reply brief. It's very, very close to the situation here. There, the party filed a cross motion to vacate. They should have filed a petition to vacate. The argument was also they defaulted because they didn't answer the petition to confirm. This court said that's an error that's subject to correction under CPLR 2001. So even if the court views the cross petition here as too bare bones, then that's subject to correction. We're not relying on the cross petition anyway because we're entitled to oppose confirmation on any ground to vacate the award. So I don't think that that's an issue at all.
Thank you.
Thank you.
State of New York versus Anthony R. You may proceed.
May it please the court, good afternoon. My name is Naomi Weinstein, and I represent appellant Anthony R. in this appeal. The trial court erred by finding Mr. R. to be a dangerous sex offender requiring confinement because the state failed to prove by clear and convincing evidence that Mr. R. has an inability to control his sex offending behavior.
Is a showing that he struggled with his sexual urges the same as showing an inability to control them?
There has to be a close causal connection. And here there was absolutely no evidence that Mr. R had was demonstrating any sexual urges. The conditions that he was violated for were non-sexual. And of course, they don't have to be sexual in nature to find someone in need of confinement. However,
there were some statements throughout the papers claiming that he was preoccupied with sex. Do you want to address that?
So, Your Honor, that was the state referring back to a prior petition for confinement in 2021. And I would note that for this proceeding, the court properly declined to incorporate all the prior proceedings. But yes, Your Honor is referring to violations that occurred in 2021, where there was some evidence that Mr. R was having some sexual urges that he was talking about with his providers. However, if you look at the whole
Was that
picture,
present this time?
no, Your Honor. In fact, the 3 days that he was in the community, he did not act out sexually at all. There was
Even if there was evidence of preoccupation, is preoccupation the same thing as an inability to control?
No, it's not, Your Honor. There has to be some evidence, and that comes from the case law, Michael M. from the Court of Appeals, as well as subsequent case law like George N. There has to be some evidence of a present inability to control his sex offending behavior. And looking at his entire history, as the court should and did, this is somebody who was successfully in the community for nearly 6 years on a regimen of strict and intensive supervision and treatment. And the evidence showed that when he had the proper supports in the community, for example, like assisted outpatient treatment, when he had case managers checking
So how do
in.
you respond to the lower court's position that when he was released on January 23rd, 23, that mentally he was in the worst condition that he previously was?
That is undisputed, Your Honor, in the record that Mr. R was showing symptoms of a mental illness. However,
And the reason for that was why?
Well, Your Honor, it's not really clear because as this court is aware,
Wasn't his medication regimen, there was an issue about the medication regimen?
there was some
Not his fault, but there was an issue about his medication, correct?
There was an issue about whether he was receiving the appropriate medication, all of the appropriate, including a mood stabilizer in addition to the antipsychotic that he was taking. And as the court observed, yes, he was, by the time he was, so just to back up a little bit, in 2021, when the first cyst petition for confinement was filed, the court did find him to be not dangerous. sex offender and returned him to the community. And then there was approximately a 4.5-month delay where he remained in the custody of Office of Mental Health and began to decline psychiatrically, such that when he was discharged in January of 2023, he was showing symptoms of his mental illness. However, again, even showing those symptoms of his mental illness, he was not acting out sexually. And the trial court erred by finding that he had any sort of inability to control his sex offending behavior. Again, showing symptoms of his mental illness does not make him a dangerous sex offender requiring confinement. And the trial court should also have considered the remedies that were available once finding that he is not a dangerous sex offender requiring confinement. There are remedies that were available for people with serious mental illness like Mr. R. To get that treatment even when he's released in the community. Because cyst is not felony probation. And that is a quote from George N. And it shouldn't be treated as such. So while yes, it's about keeping the community safe, it's also about providing treatment for people like Mr. R, sex offender treatment, for people like Mr. R who are able to
control. Is there any relevance to the state's failure to evaluate your client for AOT?
Yes, because the court, I think in its decision and in the record, did express frustration that it had suggested in the prior release of community to explore assisted outpatient treatment.
Was it a suggestion or a direction?
It was a direction, Your Honor. I don't know if it was
that was not followed.
That's correct, and it's not quite clear exactly that's not within the transcript about exactly what had happened, although the state does briefly refer to it. But there are more options than just assisted outpatient treatment. CIST contains normally over 66 conditions, and the court can add any additional conditions that are necessary, and the court could have also crafted CIST conditions to mimic assisted outpatient treatment. So it's not just about ensuring that he had assisted outpatient treatment. Yes, it's our position absolutely that the state should have explored that and made sure that he had a community support, because the evidence is that when he had those things in place for those 6 years, he was doing very well in the community. But there's other things that
if we were to agree with you, hypothetically, this person goes back, he's decompensated, there's no dispute about that, he's really decompensated. How are we assured that there are sufficient conditions imposed upon him that will, protect him and the community?
Well, one example, Your Honor, and I see that my time is up, but if I can just briefly respond. One example, Your Honor, could be the court could, as part of a CIST condition, require that Mr. R submit to a mental health evaluation at any time in the hospital. Parole could have directed Mr. R to go to a psychiatric ER for an evaluation. When Mr. R was told to report to parole, he did. Parole could have then taken him to the emergency room. So there are many ways to get Mr. R.
If require a remand is what you're saying to Supreme Court to impose those conditions, or what?
Yes, we're asking that the court reverse the order and remand for a CIST order that's consistent with these suggestions and to craft
The
them.
CIST order could require could impose on Mr. R the requirements that he attend a mental health evaluation when requested.
Yes, Your Honor, because as long as the procedural protections of the mental hygiene law, Article 9, are met, he can be directed to show up in a psychiatric ER or a CPAP, a comprehensive psychiatric emergency room for evaluation. There's nothing that prohibits, Nelson D would not prohibit such a condition being part of CIST. There could be conditions requiring him to, take medication as a condition of CIST. There could be conditions that require him to participate with a case, refer him to a case management. So there's many options for people like Mr. R who have a serious mental illness and are sex offender requiring CIST. Thank you.
Thank you. You may proceed.
Good afternoon, Your Honor. Good afternoon, Your Honor, and may it please the court. Anaga Sundararajan from the Office of the Attorney General for the State of New York. Supreme Court correctly concluded that Anthony R. cannot safely be managed in the community under a regimen of strict...
What evidence is, all you got is that he violates curfew and he takes a train into Manhattan. That's it.
Respectfully, Your Honor, there are other pieces of evidence.
What?
So you look at both the expert report from the state and the...
No. Tell me what he did. What actions he took.
Certainly, Your Honor. In addition to what Your Honor referenced, there were also 2 drug tests that tested positive for the presence of alcohol.
And 2 hours later, they were negative, which makes me suspicious of the first report, okay?
They were negative for fentanyl 2 hours later, Your Honor, not for alcohol. And Anthony R. himself acknowledged...
I understood that he was negative for all substances on the second testing at the parole office. I'm incorrect?
Specifically, the second testing was negative only for fentanyl, Your Honor. It didn't account for the presence of alcohol.
Did they test for alcohol?
I'm not sure, Your Honor. That's not in the record below. In addition, he was inconsistent taking medication.
But how does that show that he's likely to commit a sexual offense?
So based on Anthony R.'s prior history, these are very indicative of his...
Counsel, he was out for over 5 years without incident. So that argument falls flat.
Respectfully, Your Honor, he was out for 5 years. However, his mental condition here was worse than it had ever been. And his expert and the state's expert have agreed that his mental condition, combined with his activity of going out, seeking out cigarettes in this case, he admitted to seeking out cigarettes in Washington Square Park while he was wandering around. Those are significant risk factors for him. They are, in fact, the most significant risk factors for him, and they reflect his sex offending behavior. Additionally, Supreme Court found...
Aren't there ways to deal with those issues without an Article 10 civil confinement? Because they're all, the violations are, and I'm sure they're serious, but they're all sort of not, they're essentially non-sexual in nature.
That's correct, Your Honor.
Right? So why aren't there other limitations that can be placed on him under a strict regime, which this is, to address the issues that you've flagged?
There are 2 responses to that, Your Honor. First, that question of whether there are additional limitations is a secondary one. Supreme Court in this case first has to answer the question as to whether Anthony R. can safely be managed in the community. And based on its experience, based on his history, and the symptoms of his mental health...
That's the problem that I'm having, because if you're saying based on his history is 6 years in the community and he hasn't had a problem. It hasn't been perfect, but he hasn't had any problems, especially that involve sex. The court here denied your petition in 2022, right? And then, I'm sorry, I believe denied the petition previously.
Correct.
What's changed between that denial and now? All we have is he's in the community for 3 days. Yes, he's decompensated to a point, but all we have is a curfew violation and he goes into Manhattan.
There are 2 things that have changed, Your Honor. The first is, as you referenced, he is decompensated to a level that he had not decompensated previously.
And is the state responsible in part for that decompensation in terms of not providing adequate services? Because that's what the record seems to suggest.
It seems to support wholeheartedly.
It is our position that the state is not responsible, Your Honor. He received the services that he was entitled to receive and that he had access.
What about the defense's expert that there were other conditions or other things that could have been done short of confinement?
Again, Your Honor, that is a secondary consideration once the court has found that confinement is not warranted. Here, once the court has found that confinement is warranted based on his mental presentation, based on his history of committing sex offenses when he decompensates to this level, that is the end of Supreme Court's inquiry. And I would note, Your Honor, to your point...
You know, I'm a little troubled by that because this man ends up decompensated because the state fails to act on what the court directed you to do. And so now you want to take advantage of your failure to act, your failure to follow up with his treatment, and now confine him after he has served his time.
I would disagree with that, Your Honor, and point the court to transcript at 57. There it shows that in September and in November, after the court's initial order ordering his release, he was evaluated for assisted outpatient treatment. He was found to not qualify based on the statutory criteria for assisted outpatient treatment, which require, among other things, a certain number of hospitalizations within a set period of time, or an assisted outpatient treatment order that had expired within 6 months. In this case, the assisted outpatient treatment order expired in, I believe, either 2017 or 2018. It was allowed to expire because at that time, he was compliant with medication. Since that time, he has become less compliant with medication to the point where he has decompensated. Similarly, while in OMH custody before his release,
So
he
you're
was
saying he wasn't entitled to assisted outpatient treatment because he was doing too well?
At the time that his assisted outpatient treatment order was allowed to expire, again, that was in 2017 or 2018, he was doing well. Now, he has since stopped doing well.
Isn't the
But that is
issue with the record suggests is that he was doing well and the state sort of let him go, and then he fell apart. And now you're want to deprive him of his liberty because of the state not providing him with the services he needed.
Again, Your Honor, the state was providing him with the services, and the restrictions on assisted outpatient treatment are in the statute. The state doesn't have discretion to look past those restrictions and seek assisted outpatient treatment when the
But it
statute.
seems like you are now using those statutes as a sword. You can't have it both ways. So perhaps that needs to be revisited.
Again, Your Honor, the state itself does not have authority where the statute is very clear and places restrictions on who is entitled to this.
Thank you.
Thank you.
You have a minute.
If I may just briefly respond, the state argued that the issue is whether Mr. R can be safely managed in the community, but actually the issue is whether he's a dangerous sex offender requiring confinement. And that means that the state has to show by clear and convincing evidence that Mr. R is presently unable to control his sex offending conduct. And here there was not a
Is there any evidence?
I'm sorry.
Is there any evidence of that at all anywhere in the record?
There's no evidence of any sexual misconduct. In fact, as the state's expert agreed, that Mr. R, despite showing symptoms of his mental illness, was not sexually inappropriate. He did not act out sexually in any way. And the court itself also found that in the proceedings in the trial transcript, I believe it was trial transcript page 130, when the court said it was at the end of the proceeding, the court stated that there was no evidence that Mr. R was in danger of sexually acting out. And that's the real issue before this court. The fact that he may have been showing symptoms of a psychiatric illness does not mean he's a dangerous sex offender requiring confinement. And the state's testimony as to whether or not Mr. R currently qualifies for assisted outpatient treatment, that was not properly before the court. At the transcript at 119, counsel made an objection that there was no testimony to that, and therefore that's not properly before this court. Thank you.
Thank you. People versus Carl Dosier. You may proceed.
May it please the court, Samuel Steinbach Pratt from the Office of the Appellate Defender on behalf of Carl Dosier. When Mr. Dosier alerted the court at sentencing that he could not remember the incident because he had been drinking, that triggered an obligation on the part of the court to inquire into whether Mr. Dosier I apologize, Your Honor.
Did he need to say something more than that? Did he have to use the word intoxication? Did he say because of the drinking, that's why I couldn't remember, I was completely blank? Did he have to do more than what he did?
So he certainly doesn't have to say any specific word like drunk or intoxicated. The cases don't support that at all. And Mr. Dosier does directly link the loss of memory to the drinking. On page 3 of the sentencing transcript, he says that he's not quite sure because, you know, we were drinking at the time. And then a few lines later, he says he doesn't even remember the incident.
It's kind of convoluted though, right?
Yeah,
It's
a little bit.
because first he says in the same paragraph, it wasn't me. I don't remember. There was no DNA evidence, by the way. So how do I know, right? So, I mean, in one of them, it's not him. He wasn't there. And another one, it was me, but you don't have no DNA. So he's kind of all over the place, right?
So Your Honor, it's certainly not a model of clarity. I take
Thank you.
When he says that wasn't me, Your Honor, I understand that to be metaphorical because he goes on to quite forthrightly admit that he's depicted on the video. I don't think he's denying that he was present.
So it's not a question of identity.
I don't think so, Your Honor. I don't think that's what he meant. And certainly some of it's a little convoluted. I think the part where he raises the fact that he doesn't remember what happened and was drinking, that's fairly clear, and that triggers an obligation on the court to inquire further, make sure he understands that there's an intoxication defense, how it operates, and that he's knowing and voluntarily.
So the judge kind of challenges him on his sentencing date when counsel apprises the court that the defendant wants to withdraw his plea, right? And the judge says, I saw the video. You're raping her in the video, and you're beating her up, and you hit her with a lead pipe. Plaintiff, your client says nothing.
Well, I think what he does is he starts to, my client disputes what the video, what is actually shown on the video, but I don't think anything that he says undermines what he says about his loss of memory or his intoxication. He goes into sort of a different avenue for sure, but I'm not aware of any cases, certainly respondent hasn't cited any, saying that where you've brought up intoxication and loss of memory, other things you say that are unrelated to that somehow obviate the court's obligation to inquire. It's not a heavy burden on the court.
Counsel, when the defendant makes these statements, the court's response was that it wasn't going to debate it any further, right? The court at that time could have, I think, at least asked counsel whether counsel discussed the intoxication defense with the defendant. The court didn't do that.
That's exactly right, Your Honor. The court doesn't go into it whatsoever. There's
When
not
he said
even,
it wasn't up for further debate, he meant it.
Exactly right. It's a fairly minimal requirement, I think, on the part of the court to go into this and make sure the defendant is pleading guilty knowingly and voluntarily. But just none of that happened here, and so under long-standing precedent, the conviction has to be reversed.
And just one other thing, his statements in court are not the only place where he puts into question his guilt, right? In the PSR report?
In the PSI, what it says is that he admitted guilt and stated that he raped the complainant because he was intoxicated. Now, the case law is pretty clear that in determining whether the court's obligation to inquire, you only look at statements made at plea and sentencing. But I do think the PSI further supports making an inquiry, especially where it also notes that he has a long history of drinking and that he was drinking on the day of the events.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. Juliana Susu for the people. The defendant's guilty plea was knowing and voluntary, and it should not be vacated. As an initial matter, defendant's challenge to the validity of his plea is unpreserved, and for reasons that overlap with his...
How is it unpreserved when at sentencing he throws this into the mix and there's no questioning by the court whatsoever?
The court did not have to, and that sort of goes into whether it fits within the narrow exception. The court did not have to make a further inquiry because defendant did not say anything that raised significant doubt as to his guilt.
The defendant said that he was drinking and doesn't remember the incident. I don't understand how a court would miss that that's a potential intoxication defense.
Defendant does not link those two statements together. So
They're almost back to back. We were drinking at the time. You saw the video. I saw the video. That wasn't me, Your Honor. That wasn't me. And I feel that, to be held responsible when I don't even remember the incident. You're making it sound like he made one statement today and the next statement the following week. It was sentences apart. If you connect the two, intoxication, why not ask the question?
Sure, it would have been helpful to ask a question more for
It's not about helpful, counsel. He's not a lawyer, right? He may not even know that he has an intoxication defense. That's the point.
To raise a possible intoxication defense, it's not enough just to say that you were consuming alcohol or you were intoxicated. It has to be that...
He said that he was drinking alcohol and didn't remember a rape.
Defendant makes a claim that he was drinking at the time of the offense. Yes. Then he goes into a discussion not to say that I was drinking and for that I do not understand what I was doing when I committed the rape. It's that the rape didn't even happen.
Am I correct that in this case, the defendant and the victim woke up on the street following this encounter?
Yes, it was in the middle of the night.
So I don't know about you, but it seems really odd that a woman who's just been beaten and raped would fall asleep with her victim on the street, with her perpetrator on the street. That seems to suggest that perhaps everybody was drinking.
The defendant choked her out. She didn't just fall asleep. he choked her out while he was beating her and raping her. And when she came to, he then hit her with a lead pipe. So that goes to that.
So you're saying she wasn't drinking?
We have no evidence to say that she was drinking. We only have evidence of defendant's statement that he was drinking at the time. But again, that's not.
Doesn't he say we were drinking?
Mm-hmm.
Oh, okay. Then yes, he says we were drinking, but we other than
And
that
I would
statement.
imagine this victim was taken to a hospital having been hit by a lead pipe in the head.
Yes.
And typically blood is taken, so we would be able to find out the answer to this question.
I don't have that information right with me. I knew it was a few hours later, so I don't know if they would have detected alcohol still in her system if she was drinking and how much she was drinking. Again, though,
And I'm not blaming the victim, to be clear, okay? I'm just illustrating the facts here.
Of course.
That this was,
yes,
not your typical encounter.
Definitely not, no. Again, the main argument that defendant is making to the court is that not that he didn't know what he was doing, but that a rape did not occur. And he evidences that by his statement, saying that it wasn't him on the video. There's no DNA, no
Also, you're
semen.
parsing them out, right? You're parsing out the statements and you're picking and choosing the ones that are convenient for the prosecution. But the statement, I don't even remember the incident, that relates back to the alcohol. I don't know how you could unattach that.
At the very least, not that it would have ultimately undermined the plea, but
a duty to inquire.
A duty to inquire, right? Wasn't it necessary to clean up this record on the part of the court to make sure that it was clear that he was certainly aware that if what he says is true, that could lead to a possible intoxication defense, and that in so pleading, he was waiving that. We need to know that as a part of this record, don't we?
Yes, I think the court as well took into consideration the plea minutes in which defendant confirmed twice that he understood his options and he understood that he was waiving any defenses and wanted to continue forward with the plea. So the court as well had that information with it. And the court responded wholly to the defendant's argument before him, saying that the video makes absolutely clear what was going on. There's no question that there was a rape, and this purported memory loss was contradicted by the evidence and didn't need to be credited by the court in the first place because defendant made statements that evidence that he did not.
That's fine. But isn't the issue whether or not that the court should have just made a simple inquiry about it, and not what the court would have done with respect to the inquiry, but just so that the defendant knew what his rights were?
Would it have been best practice? Yes, but the court was not required to in this situation. Okay. And unless there's further questions by the court, we'd ask that you affirm. Thank you.
Thank you.
Just very briefly, Your Honors. As Your Honor pointed out, Mr. Dosier is not an attorney. Statements certainly could have been clearer, but he does explicitly link the drinking to his loss of memory, and that's what the case law really focuses on in when the duty to inquire is triggered, is loss of memory and an inability to remember what had happened. That was more than met here. The plea colloquy, the single question about whether he had discussed defenses with his attorney, I'm not aware of any case holding that kind of boilerplate question is sufficient to obviate the court's duty to inquire at a later date when a specific defense is implicated by the defendant's statement.
And that was a general instruction before this issue even arose.
It was a general instruction before the issue even arose, and it was not specific to the defense at issue. And in the Mox case, the Court of Appeals that said, in fact, even when the specific defense is named and there's some indication there was a discussion, that might still not be enough. Of course, here there's much less than that. I understood the record to be undisputed, essentially, that both parties were drinking, that they had gotten together previously in the night, that they had been drinking before the incident occurred. And so I think under the circumstances here, the court clearly had a minimal duty to inquire and ensure that Mr. Dosier was pleading guilty voluntarily. Thank you.
Needum and Company versus UpHealth Holdings. You may proceed.
Thank you, Your Honor. May it please the court, Joseph Palmore for Appellant UpHealth Holdings. The commercial division committed several critical errors of contract interpretation, which led it to disregard factual disputes and erroneously enter summary judgment for Needum. I know there's a lot going on in this case. I'd like, time permitting, to address 3 issues: successor liability, like what I think of as the denominator problem. Is was Needum's fee properly based on all the value that flowed not only to its client but also to the target companies, and then the cloud break issue. On successor liability, the root of the error was a kind of a mechanical application of successor liability that was used to override the plain terms of the contract.
So you're referencing that the amended agreement states that the agreement's between Needum and services, correct?
Yes, it's a 2-part argument, Your Honor.
Okay, but doesn't the agreement also state company and its affiliates? And could Holdings be an affiliate, i.e. a successor affiliate?
I think that, yes, that is our point, actually, that the contract contemplated that an affiliate would be another party. That's in paragraph 15. That is our very argument. Holdings was an affiliate of Services. It became Services' parent company. And the plain language of the contract puts an affiliate in the other party box. Now,
it's not the company, in other words.
It's no longer the company, and Needum says, well then, and the commercial division agreed, well then successor liability makes it the company. But parties are free to—
But I want to, why don't you address that? Because it seems to be a good argument in terms of the transaction between Services and Holdings, that there is successor liability, no?
Well, we actually agree there is a form of successor liability here. We're not trying to get out of paying a fee. We agree we owe a fee.
You agree, you think it's a lot less. But
Holdings, right. So there's no question that we succeeded to the liability and we owe a fee. That's stipulated. The question is, how is that fee calculated? And does the party's contract control that calculation? Or do kind of background rules of successor liability override those contractual choices? And the SmithKline-Beecham case from the Third Circuit is very good on this question, and it says that we cite in our brief, parties are of course always free to contract around background legal rules. And here they did. They defined company only as Services. They defined other party incredibly broadly as any other entity.
Only as Services, even after Services ceases to exist?
Services,
because Services was dissolved on April 8th, 2022. So who stands in the shoes of Services after that dissolution?
Well, that was after all this happened, Your Honor, and so Holdings stands in the shoes of Services in terms of having to pay a fee. But when you look at the calculation of that fee, the question is, was there an other party target company acquisition? Which box does Holdings go in? Is it the company or is it an other party? And this affiliate language that we were talking about—
You're saying it's the latter.
Exactly. The affiliate language quite clearly puts it in the other party box. And then calculation kind of consequences flow from that.
But again, based on the transaction, why was Supreme Court wrong to say, in fact, there was successor liability? So it became, in essence, the company. I'm talking about Holdings.
Because that then kind of erased that affiliate provision that Your Honor mentioned right out of the contract, right? Because that affiliate provision says an affiliate, and this clearly was an affiliate, is another party that might do the acquisition. That was a contractual choice in this contract that Needum itself drafted, and using kind of successor liability principles in a blunderbuss way to override that contractual choice is contrary to law.
Does it make any difference that the court also found that there were many hallmarks of de facto merger, so it wasn't just the successor liability, but it was also a de facto merger? Does that change your analysis at all?
No, Your Honor. Again, we don't dispute those principles in terms of do we owe a fee. All of that goes to, we're not, this isn't one of those cases where someone is trying to completely get out of paying a contractual obligation or get out of paying a tort plaintiff through, some change of form. The question, again, is the calculation of the fee.
So do you want to talk about that more? I mean, how do you get to your calculation?
Sure. So our position is that the other party is Holdings, and its acquisition of the target companies, that's the transaction, right? And this Gig Capital 2 Holdings transaction is a transaction between two other parties. It falls outside of—
So that you have no responsibility to pay a fee for that?
That's not the base, that's not one of the inputs into the calculation, Your Honor.
But wouldn't the definition of aggregate purchase price support Needham's position here? I assume you're going to address that.
Yeah, I would like to go to that next, Your Honor. So even if you disagree with everything I've said on successor liability, we still have that aggregate purchase price issue, right?
So why do you say it doesn't support your adversary here?
Because it's the aggregate purchase price is the value that flowed to the company or its security holders, right? And the company is defined in paragraph 1 as services, and the target companies are separately defined in paragraph 1. These are separate entities. What the commercial division's error was that in basing the fee calculation on all the value that flowed not only to holdings, but also to the target companies, which weren't clients of Needham, the fee was calculated based on that 100%. There is at the least an ambiguity about what is the company. Is it the company that signed the agreement with Needham? Or is it the very differently constituted company that had brought the target companies into the fold? The commercial division said it was the
Wasn't
latter.
that the whole point of this transaction to start out with, was acquiring these other companies and moving ahead as a big global company to do this type of work? I mean, I thought that was the whole point of it all.
That was the point, Your Honor, and Mr. Stravis from Needham testified that was the point. That's why they were engaged, was to roll up to acquire these companies and combine them on one platform. So that's why we think those acquisitions, actually, this goes back to the first argument, are the relevant transaction, because that was the point of this, was to acquire these target companies, and that's what Needham did. If I could just briefly address the
Still
cloud
have
break.
time. Until it goes red, you're good.
It goes fast, Your Honor, I know. On the CloudBreak issue, here's the key point. CloudBreak wasn't a target company. It had unilaterally walked away.
Sure it was. It was a target company.
It may or may not have been a target company for a time, but the rights to acquire CloudBreak weren't assigned for consideration to Gig Capital II. It unilaterally backed out of its term sheet, and it unilaterally went to Gig Capital II for acquisition. And at the time that Needham said, hey, we should add CloudBreak to attachment 1, they were gone. They had already married up with Gig Capital II. So it wasn't proper to add them at that time.
Okay.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court, Ed Flanders of Pillsbury, Winthrop, Shaw, Pittman for the plaintiff respondent, Needum Co.
How do you respond to your adversary's argument that Holdings is an affiliate of Services?
Well, it's the successor of Services. The record is clear that Services became Holdings. Services ceased to exist.
You're predicating essentially on successor liability, right?
Yeah,
but I think your adversary's point is then how do we read the contract? Because we have to give meaning to the language in the contract as well.
Well, but he's referring to language in the section 15 that determines how to calculate Needham's fee. It doesn't define the transaction as taking into consideration an affiliate. Right? So the first paragraph of section 15 defines a transaction, like a business combination or a merger with a SPAC. And then it goes on in the next paragraph. If any portion of that transaction involves the acquisition of a target company by an other party, then for purposes of calculating Needham's fee, then the aggregate purchase price paid for the acquisition of that target company gets included. So you have the Gig Capital II SPAC transaction. You look at the aggregate purchase price that was received or paid in that transaction, and then you add to that where the other party, the SPAC, directly acquires a target company, CloudBreak. So what Mr. Palmore is doing is he's trying to conflate those two paragraphs. But let's be very clear. Nowhere in the definition of transaction does it talk about acquisition of target companies or assignment of rights to acquire a target company to an affiliate. And he's referring to cases that have no application here. An affiliate is, of course, not a successor, right? In order to be a successor, You have to assume the debts and liabilities in the same ownership, same physical location, same management, all of those things.
Which is what Holdings did here.
It's exactly what Holdings did, and that occurred on October 26, 2020, long before the Gig Capital II Holdings business combination. And Services entered into a letter of intent to do a business combination with Gig Capital II, right? And so that's obviously the obligation of Services, right? And then Services does a de facto merger with Holdings. Holdings then does that transaction. So it's the same transaction, the same fee, whether it had been executed by Services or by its successor, Holdings. And to Mr. Palmori's point about who received the value here, the aggregate purchase price was the value paid to holding security holders. The former owners of the target companies at that point were owners of the holding stock. And you can see that in the business combination agreement. There's a list of stockholders in the back, and it isn't just the original stockholders of Services, it's the former owners of the target companies. And what's really telling here, Your Honors, right, is that Needum sends a calculation of its fee in January 2021. It tracks the definition of aggregate purchase price, lays out the components. No objection from anyone at UpHealth Holdings. Now, Mr. Palmore will tell you that Dr. Katz objected, but Dr. Katz was with Gig Capital II. And in fact, Dr. Katz testified in no uncertain terms. He said, and this is at R2616, when he was having the conversation with Mr. Malik where he supposedly objected, he said, quote, "I was never your client, and this is going to be resolved between you and your client, Holdings." And then again at R2618 to 19, quote, "I interfered on January 28th as a goodwill to try to resolve what I perceived to be a misunderstanding." In the real world, right, a company like an advisor, an investment bank, sends a calculation and says, here is my fee, $31.345 million. And no response from UpHealth Holdings. UpHealth Holdings doesn't say, what are you talking about? That's not the transaction. The transaction was the acquisition of the target companies. Well, I want to just quote one more thing for Your Honors. In their counterclaim, UpHealth Holdings, when talking about the acquisition of the target companies, and this is at R73, paragraph 55, quote, "Needum played no role in these acquisitions," end quote. And there is no dispute that Needum was the exclusive financial advisor, first to Services and then to Holdings in connection with the Gig Capital II Holdings business combination. Press releases, right? The business combination agreement itself saying except for Needum, no other investment bank is entitled to a fee. The acquisition of the target companies that occurred previously, first of all, it's not even a standalone transaction. It's expressly conditioned on the business combination, because that's where all the capital is going to come to purchase the target companies. And in those very agreements, which we had nothing to do with, Needum represented to each of the target companies that no investment bank is entitled to a fee. And then lastly, CloudBreak. The definition is clear. Once Services enters into a definitive acquisition term sheet with Services, it becomes a target company. It's expressly defined. And
It
then,
has to be automatically added.
pardon?
And has to be automatically added to the list.
It says shall be updated. So what Mr. Palmore says in his reply brief is that, oh no, it's defined as having a definitive term sheet and being on attachment I. Well, of course that's not true. You just look at the definition and the as listed in attachment 1 comes after the definition. But the whole point of it is when a target company is added for acquisition, like Cloudbreak was. Cloudbreak didn't sign a term sheet until October 15th, 2020. At that point, it's a target company. And that was the whole reason that Needum put in the language in what it described in its cover email as edits to the SPAC merger section. If the other party directly acquires a target company, for purposes of calculating Needum's fee, you include that. That's exactly what happened.
How do you respond to the argument that that there was no signed writing modifying attachment 1, and therefore Cloudbreak is not part of it?
Well, but Cloudbreak was a target company as of the day that it signed its term sheet, October 15th, 2020.
Is there an inconsistency between those two provisions, and how do you reconcile that?
I don't think there's any inconsistency in any provision. So paragraph 1 is clear, right? That Cloudbreak on October 15, 2020 became a target company because it entered into a definitive acquisition term sheet, full stop, right? And then the paragraph 1 goes on and says, which are those target companies that are listed in attachment 1, which shall be updated, right? You have no choice.
In other words, you don't require a modification, essentially.
Well, yeah, it doesn't say, which shall be agreed in writing. The case that Mr. Palmore relies on is a Second Circuit case where the parties didn't rely on a boilerplate no oral modification clause. The provision at issue said, that the company will not become a selected target or a target unless the parties agree in writing. You contrast that with this, right? It doesn't say that, right? So, and update is completely different than modify, right? I mean, update just means bring it up to date. Modify means change it.
We got you. Thank you. 2 minutes.
Thank you, Your Honor. A couple quick points. Section 15A, what we're relying on, is part, obviously, of Section 15. It's 15A, and says if any portion of the transaction, capital T, involves the purchase of a target company directly by the other party rather than the company, and then it talks about how the fee is calculated. So this is clearly part of, contract is to be read as a whole. This is part of defining what the transaction is. And then it goes on to say, for the avoidance of doubt, and it has this affiliate language. This is all to be read together. It can't be parsed as, well, the transaction is defined over here, and this is completely irrelevant to the defining of the transaction. My friend on the other side says that the earlier part of 15 can't possibly cover acquisition of the target companies, but I would call the court's attention to A(1), which says a transaction can be any merger, consolidation, reorganization, or business combination. That's clearly what these were. We heard a lot of factual argument here, Your Honor. This is an appeal from the grant of summary judgment against us. And my friend on the other side is asking the court to adopt a series of inferences in Needum's favor. That turns the standard on its head. For instance, in the very communication where they transmitted the fee calculation, they also attached to it an expense estimate for all the expenses for all the professionals for this transaction, which is mathematically irreconcilable with the $31 million. Mr. Malik, we want to talk about facts. Mr. Malik told Mr. Katz that this fee was clearly excessive and that they were insisting on it only because they wanted to make more than Oppenheimer. They've internally calculated a number of different fee calculations, the lowest of which was $8 million, and that was found its way to UpHealth. The contractual arguments on successor liability, on aggregate purchase price, and how it's calculated, at most create an ambiguity in this contract. And once you say there's an ambiguity, then there should be a remand to resolve all of these factual questions and construe the contract correctly.
Thank you so much.
Thank you, Your Honor.
Weiss versus Park Towers South. You may proceed.
Good afternoon, and may it please the court. Melissa Danowski of Morrow Lilling Party for defendants appellants, Park Towers South. There's three reasons why Park Towers should have been granted summary judgment in the court below: on duty, on proximate cause, and on superseding intervening cause. Now, the Court of Appeals in Scurry recently held in those two cases that there's no per se rule that just because an attack is targeted, that there can't be that's an issue of fact.
Wasn't Park Towers negligent in not noticing that Mr. Nolan was wandering around the building after he'd first gone in saying he was going to a commercial tenant's office?
No, Your Honor. They're doormen. People frequently get lost in a building, and
don't they have an obligation at that point to do something about that, as opposed to just letting a person carrying a large, heavy bag wander around the building?
Your Honor, in hindsight, we know it's certainly, worrisome. But if we look at it from the doorman's perspective, if you look at the record, at the logbook on page 71.
I'm not sure why we should use the doorman's perspective. I think we should use your client's perspective on how they maintain a safe building and what their obligations are to what they require a doorman to do.
So
a doorman may not have a thoughtful perspective on security, but I would expect that would be your client's obligation.
The duty, as enunciated by the Court of Appeals and just reiterated recently in Scurry, is to provide reasonable, minimal security precautions.
But you do have security protocols, right, that seem to have been violated here.
We would disagree that they were violated.
Why don't you talk maybe about some of your stronger arguments?
Absolutely. So Mr. Nolan came to Park Towers and he lied to the doorman. He told them that he was there to visit Bright Kids, and he asks Mr. Ocasio, the doorman, where is Bright Kids? The doorman says it's on the 4th floor, this is the elevator you take. Clearly, given that interaction, he doesn't appear to be somebody that knows where he's going.
Look, again, I think you should address stronger arguments, because at the end of the day, they have video surveillance. And this man gets on an elevator going in the wrong direction, walks down a hallway to the other elevator, accessing the residential units, right? And gets on that elevator. So this is not your strongest point.
Well, I do want to direct the court to the logbook, because not only did Jacob Nolan sign in, but in a half-hour period between 9:10 to 9:30 in the morning, 13 other visitors.
Counsel, you really need to listen to the court when we're trying to give you direction, okay? This is not your strongest argument. Full stop. You have other arguments. I suggest you get to them.
Your Honor, this case is analogous to this court's case in Estate of Fahey, where there was a former psychiatric patient. He entered into the building, passed the doorman. That doorman, in that case, also did not. The plaintiff claimed that they failed to follow their protocols because the doorman didn't interact with that patient at all.
Okay, here, let me help you out here. Here, this visitor to the building ultimately ends up at the plaintiff's unit, correct?
Yes.
And he storms in during the plaintiff's psychiatric session with a patient, correct?
That's right.
And the plaintiff is able to get him out of his unit and locks the door.
Yes, that's right.
Is there anything that happens after that that kind of shifts the responsibility about what happened here from your client to someone else?
Yes, Your Honor.
Okay.
What you're speaking to is the issue of superseding cause. Plaintiff's act of inviting his assailant back into his apartment unit to use the restroom and wait there while he printed out these important forms, that was the superseding intervening act that cut off any but-for causation, any chain of causation that could be traced back to the doorman and his alleged inability to.
When we say that as a matter of law, is that, I imagine your adversary would argue that's an issue of fact. Why do you say that we should find that it's a matter of law?
Because as this court held in Benitez and also in Fisher, it was in Benitez, it was the plaintiff's act of opening her locked door and failing to use the peephole that was provided. That was the, if I could just briefly.
Of course.
That was a superseding intervening cause, that severed causation. And again, in Fisher, the plaintiff's failure to report that her key was lost and then somebody stole her key and entered, that was the superseding intervening. So it was just when it gets too far attenuated because of something the plaintiff does, as is the situation in this case, there cannot be proximate cause.
Thank you.
May it please the court, Roland Acevedo, I represent Dr. Michael Weiss. We contend that the trial court correctly denied the motion for summary judgment. The evidence here is a little different than other targeted cases because in other targeted cases heard by this court and decided by this court, there's usually a dispute about how they got into the building.
What about this superseding cause? I mean, that's really been concerning me. He comes up, he comes into the Dr. Weiss's office. He interrupts a discussion with the patient. He says, look, please go outside. He goes out, he locks the door. The patient leaves. He said, doctor, I want to tell you that that creepy guy is still hanging around outside. He says, okay, thank you. He goes out and then he lets him into his apartment. It was locked. He could have said to the patient, please go ahead and leave. Why did he let him into the apartment? And isn't that a superseding cause that takes it away from the defendant's responsibility?
It isn't. Chivalry isn't dead. The patient comes back and says, that guy's in the stairwell. She's clearly frightened.
But that wasn't his only option. He could have called out. You've got a doorman building and you have someone in the building who shouldn't be there. He could have called security and said, I need someone to come upstairs because this guy busted into my office.
Yeah, but that's using hindsight. Whether or not it was
common sense. I mean, he'd already excluded this man from his office earlier. He obviously thought that there was bad blood in some level between him and this guy. And it's not hindsight to say, gee, you don't let someone like that into your apartment when you have an alternative, a very simple alternative.
Judge, the question really becomes whether or not it was foreseeable whether Nolan was going to attack him.
But let me turn the question. How is it foreseeable for the defendants here? They don't know him. Your client does.
But he was acting suspicious in the building. He did more than what Your Honor raised. He didn't just walk from the 58th Street side to the 57th.
Wait a minute. He was acting suspicious in the building. That's not more suspicious than barging into a session. He barges into a session and he's excluded, the door's locked. Plaintiff is safe.
No, I believe it is more suspicious that he's sneaking in and out of stairwells, leaving the building, coming back in, and going without checking in with the doorman.
Yeah, but that goes to whether or not the defendant followed the safety protocols. And you see, that's not our concern here. Our concern here is whether or not plaintiff engaged in unforeseeable conduct in permitting Nolan to re-enter his apartment.
So
that's the question.
For Dr. Weiss to be the proximate superseding intervening cause, he has to recognize a danger and discard it.
Nolan barges in with this big duffel bag. His ex-partner, there's an estranged relationship with the ex-partner. He's I think the cousin of
He's the first cousin, Your Honor.
And the ex-partner stabbed him. So, I mean, previously.
The ex-partner stabbed him many years before. I'm the attorney that tried this case in family court. I know the facts intimately well. She stabbed him many years ago in the neck.
But then why would you let her first cousin into your home? That just doesn't make any sense.
He didn't let the first cousin into his home. He barged in.
He did the second time. But the second time, after forcing him out, he then let him into his apartment.
So Nolan asks to use the bathroom. He's in the hallway with Nolan. He makes a judgment call because he has another patient coming to get the papers to him and get him out. He doesn't feel at that time that there's any threat. He threw him out the first time. He didn't anticipate seeing him the second time. To shift the burden to him, this is exactly what the court decided in Scurry. These are factual questions on the proximate cause, and there can be more than one proximate cause for someone's injuries.
Absolutely, but the issue is whether this is an intervening, unforeseeable cause of what occurred. So
Correct, and we submit that it wasn't. Under those circumstances, he encounters him in the hallway. He says, "Can I use the bathroom?" He wants to get rid of him. He has another patient coming. He goes in. He's not in the same room with him, by the way. Nolan's in the waiting room.
The gloss
He's in the consulting room.
you're putting a gloss on the facts that like everything is hunky-dory. I mean, in fact, Nolan barges in, gets him out, and then the client, the patient says later, there's that creepy man still outside.
I understand.
The patient comes in, locks the door, as my colleague suggested, call the doorman, it's over.
But the burden doesn't shift to him to stop exactly what he's doing and call the doorman. He lives in a doorman building. They have security protocols which they didn't file.
But he could have called the doorman, and he didn't do that.
But this case isn't like Fisher and the others where somebody at nighttime opens a door to a stranger without looking through a peephole or buzzes the front door
No,
to
it's
let a
worse than that
stranger
because
in.
he lets in somebody with whom he has every reason to believe that he has a bad relationship because of his relationship with his
The
ex.
record here does not show that. The
Okay,
record shows.
thank you. We are out of time.
Thank you, Your Honor.
Your Honors, I'd like to make two quick points on rebuttal. One, as my adversary said, in order for the superseding intervening defense to apply, and it does here, the plaintiff has to recognize the danger and disregard it. And he was very clear, he didn't foresee the attack, for sure, but he did, on pages 378 to 379 of the record, recognize that he was concerned with the bag, that he may try to bug his apartment because that's something that he knew and he believed his ex-partner might do. So he knew there was some, in addition to the barging in the office, obviously, he had that apprehension and disregarded it anyway. He tested, he was questioned at his deposition, well, why didn't you insist he leave the bag outside? And he really didn't have a reason for that. So he absolutely was a superseding. And in addition to the two cases I cited, there's another case I cited in the brief that this court decided in 2012, and that was the Van Leeuw decision. And in that case, it wasn't a nighttime situation where somebody barged in because the lock was broken. There, the plaintiff was a superseding intervening cause because she admittedly opened the exterior door, let her assailant in, and then something happened, some altercation, and then she wanted to exclude him from her apartment. And it was at that point that she was unable to because that lock wasn't working because she didn't want to fix it. She told the building, I didn't want to fix all she had was the deadbolt. She didn't want to fix the lock citing cost. So it's a very similar situation where the plaintiff, ends up inviting their assailant into the apartment. So,
thank you.
Thank you for your time.
$5,400 Company versus New York State Division of Housing and,
That's submitted.
oh, sorry. Goine versus Nurian. You may proceed.
Good afternoon, Your Honors. My name is Elliot Zucker from Aronson, Rappaport, Feinstein, and Deutsch, appearing today on behalf of the defendants' appellants, Dr. Narsessian and New York Presbyterian Hospital. From the time this action started until the completion of discovery and the filing of the note of issue, the plaintiff here was operating under a single set of theories, all of which involved the post-operative care that was received by this patient. Specifically, that there was a failure to treat an infection, that the patient was prematurely discharged, things of that order.
Doesn't the original bill, at least according to my notes, and they're not perfect, the original bill of particulars says, it references pre-op care, right?
So I was going to get to that, but I'll jump ahead. The original bill of particulars does use the word preoperative, okay?
So but you just said it was all related to post-op, so that's clearly not true.
Well, again, so let me finish. The initial bill of particulars uses the word preoperative, but it uses it in a single sentence, which says that there was negligence preoperatively, intraoperatively, and postoperatively, okay? That sentence is then followed by 10 pages of actual particularization, all of which deals with the postoperative period.
But that just doesn't mean it wasn't raised. It means it wasn't raised in great detail, but it was still raised.
It wasn't.
But more to the point, you know, a lot of us were in the trial court doing those cases, and if there's an ambiguity in the bill of particulars, you have a remedy, correct? You can ask for an amplification. You can do.
Well, the purpose of the bill of particulars is to amplify. Okay, when this bill of particulars was served, it did amplify. Okay, because the original complaint just said that there was negligence. Okay, this did amplify. It amplified lots of things with regard to the postoperative care, and that's where all the discovery went. That's what all of the discovery was about. Okay,
But no dispute that you were on notice of the claim. It's just that the focus of the claim, what you're saying, is on post-op as opposed to.
I don't even think it's fair to say that. I think even saying the focus of the claim is, I think that neglects you can't say that the defendants were negligent.
So when are you saying that you became aware of the fact that the plaintiffs were focusing on the fact that you failed to call in a vascular consult before the procedures? When did you become aware of that?
There's two things. First, we were really made aware of it when we received opposition to our summary judgment motion. And as you know, the law in this department and all departments is very clear that you can't change your theories in opposition to a summary judgment motion. Now, the plaintiff's going to stand here and tell you that they served what they've called
other bills of particular,
supplemental bill of particulars. Okay, you'll notice that they very cleverly label all of their bill of particulars supplemental bills of particulars, whether they're actually supplementing or they're amending.
They're called supplemental, yes.
Right, they're all just labeled supplemental. This particular bill of particulars, which was the first one to mention anything preoperatively particularized, was served at the same time as the note of issue.
Counsel, what I don't understand is that in support of your motion for summary judgment, you submitted expert affidavits, and each of your experts addressed the allegation that they should have obtained a vascular consultation prior to these procedures being undertaken. So it seems to me that there must have been some reason you addressed those issues about preoperative care in your experts' reports and submitted in support of the motion for summary judgment.
In doing so, our experts were trying to explain why this particular operation was necessary. Okay.
But that doesn't explain why your experts would discuss specifically whether
why he's an appropriate
whether or not a preoperative vascular consultation was necessary.
Because he's trying to show that we were trying to show that he was an appropriate candidate for surgery.
I don't know, that doesn't follow at all, but go ahead.
Okay, in any event, to get back to the fourth supplemental bill of particulars, which we argue was really the improperly labeled second amended bill of particulars, the defendants rejected that document because it was a second amended bill of particulars. It was the second bill of particulars the plaintiff served that amended or added to the allegations of the original bill of particulars. When we rejected that, the plaintiff did nothing to try to get that bill of particulars approved by the court. That fourth amended bill of particulars is actually not part of this record. It is not the basis of the lower court's decision. The lower court's decision was based solely on the fact that that very original bill of particulars used in the middle of that one sentence the word preoperatively. And it's our position that the word preoperatively, followed by 10 pages of verbiage about postoperatively, does not constitute sufficient notice.
Thank you.
Good afternoon, Your Honors. May it please the court. I'm Barbara Goldberg. I'm representing Dr. Meliaris, who, as the court is aware, is the plastic surgeon who came in a few days after the knee replacement and performed a flap procedure to treat the fact that the wound was not healing. The first point that I'd like to make as to why the plaintiff's opposition was insufficient to raise issues of fact as to what was concededly a prima facie showing of entitlement to summary judgment as found by the Supreme Court. The expert affirmations were not only redacted, but they were completely unsigned. They didn't even have a signature line. It's impossible to tell if these affirmations were ever signed by the experts, and they were not made available to the Supreme Court.
So you raised the issue, correct? You flagged the issue for Supreme Court?
Yes, Your Honor.
And what did Supreme Court do?
Supreme Court didn't address that issue. That issue was not addressed, but
so the court, in effect...
The court considered the affirmations on the merits, and I guess implicitly considered that that was a defect. But this court has held in the Mattis against Zhao case that an opposition to a summary judgment motion failed to raise an issue of fact because the expert affirmation was, quote, unaffirmed, unsigned, and redacted the name of the expert, and the plaintiffs failed to explain why the affirmation was unsigned and redacted and did not provide the
Well, I mean, look, we know that the names are always left off of the plaintiff's expert affidavits, and that's in mid-mail cases, and we know that's been going on for years. And if the judge had been concerned about it, the judge could have asked for that in camera or whatever, but she went on and considered that. I don't think that throws out her whole decision. I mean, this is a very common thing all the years when I was back doing med-mal cases.
I would just submit, Your Honor, that the plaintiff should have offered to make it available. I don't think that was done here. Now, I'll move on to my next point is that once we get to the merits of the plaintiff's experts' affirmations, they were insufficient to defeat Dr. Maliaris's prima facie showing of entitlement to summary judgment because the opinions of both plaintiff's expert plastic surgery expert and the expert vascular surgeon were very conclusory, and in fact, they were inherently self-contradictory.
How so? What was contradictory about them?
Well, I'd like to respond to that, Your Honor. That
Good, I'd like you to.
Yes. The expert affirmation said that at one point, this is the plaintiff's expert affirmation, he indicated that the washout and debridement of the left knee wound and the muscle flap procedure performed by Dr. Maliaris was indicated. That's at pages 4165 to 66 of the record, but then in the same paragraph said that the gastric flap was not an appropriate procedure to address a non-healing wound if the flap itself had a compromised arterial blood supply. The expert then, quote unquote, disagreed with defense expert Dr. Scher's opinion that a washout and debridement was indicated, even though the expert had offered the very same opinion. The plaintiff's expert had offered the very same opinion, and the plaintiff's vascular surgeon offered a contradictory opinion as well, indicating that the washout and debridement was not proper, even though the plastic surgery expert had said that it was. So if the plaintiff's experts disagree, I don't think that there's sufficient.
I thought the disagreement was in proceeding with the procedure without the vascular testing.
And
because after all, this was a plaintiff who had various comorbidities, diabetes, and we all know that someone who's diabetic, their wounds heal differently and sometimes not at all. And this man had a history
and he also
of having wounds that didn't heal. So it would seem that with a patient like that and his other underlying conditions, that a vascular test would have been indicated prior to surgery.
But it's interesting, Your Honor, that even after the surgery performed by Dr. Maliaris, the subsequent surgery performed by Dr. Morrissey, who was a vascular surgeon, there were tests done after Dr. Morrissey's surgery that showed that there was still good blood flow, and there was there's no indication.
Did you just say tested after the surgery? That is the point, isn't it? that it should have
Yeah,
been
but-
before the surgery.
Yeah, well, and may I just make one very quick point?
Yes, of course.
There was also evidence that's amply documented in our briefs that prior to Dr. Maliaris' surgery, there were pedal pulses of other pulses detected, and plaintiffs.
And doesn't the record reflect that those pedal pulses that were detected quite some time before the actual surgery?
No, they were detected, I believe, on the day of the surgery.
That's
the day
not
before
my
the
recollection of the record, but I'll look at it again.
All right.
All right? Thank you.
Good afternoon, Your Honors. Jason Steinberg from Harris Keenan Goldfarb. I represent the respondent. I think the strongest argument here, at least on my client's behalf, is certainly that there is an issue of fact as to whether or not there was a deviation from the standard of care. The expert, or at least the vascular surgeon who provides really the most in-depth affidavit here, was very specific on the deviation of the standard of care, and that is when you have a patient that has a history of diabetes, a history of smoking, triple bypass surgery, coronary artery disease. He was evaluated a few months before the surgery was performed, and he was deemed to already have peripheral vascular disease. And he had atherosclerosis in the lower extremity, exhibiting claudication, wounding in the leg, and all those were visible signs of a loss or inappropriate
Counsel,
blood.
I hear all that. I wondered if you could just address briefly defense counsel's allegation that this was not the focus of your case all along, and it didn't come along until like the fourth amended or a supplemental bill of particulars.
Okay.
And that
I would
you just mentioned pre-op and then just talked about post-op, which is not obviously what we're talking about.
All right, I will focus on the procedural now.
Thank you.
The bill of particulars on Appendix 3952 specifically states, this is the bill of particulars to Dr. Necessian, that they were negligent in the treatment, care, and management of the plaintiff preoperatively. And I now want to direct your attention to A3954, where we also say in the very same bill of particulars that Dr. Necessian was negligent in failing to elicit and obtain a proper, correct, and accurate history of coronary artery disease and the possibility of peripheral arterial disease and or the proclivity of infections relative to the plaintiff's signs, symptoms, complaints, and conditions.
This was in the original bill of particulars?
That's in the original bill of particulars, okay?
Thank you.
And then, 3 years before we filed the note of issue, we served a second supplemental bill of particulars to Dr. Maliaris, and we alleged that she was negligent, or he, I apologize, that Dr. Maliaris was negligent in the management of the plaintiff's preoperative care and in failing to properly recognize the vascular condition of the plaintiff. That is in a second supplemental bill, but this is all on the record. They were aware of it. They were served with the bill of particulars. And to make matters worse, we then did the fourth supplemental bill of particulars, which we filed with the note of issue. They rejected it, but they didn't file a motion to strike it. And being aware of those claims, they had 120 days to file a motion for summary judgment wherein they did address all claims of preoperative care. So there's no prejudice in that regard as well. As far as the affirmations, I have the unredacted version with me if the court is willing to accept that. If it's not necessary, then I will have it. I can submit it after the argument if anybody wants to take a look at them. They were all signed before we filed the motion papers. Okay, thank you.
Thank you. You have 1 minute.
Just very briefly, I hope the court will appreciate my concern with the idea that you get a bill of particulars which says very generally there was negligence throughout the treatment period, and then has 10 pages of particularization with regard to only one period, and then the plaintiff abandons every single aspect of that when it comes time for summary
Counsel
judgment
just
motion.
read from that original bill of particulars saying that it also said that Dr. Nersessian failed to elicit proper history, which is certainly part of preoperative
But it certainly not has anything to do with getting a vascular consult.
How do you address his supplemental on number 2?
Supplemental, that one wasn't even addressed to my client, as I think he just acknowledged. So
But clearly, it was raised,
Not
and so it was an issue in the case.
but not as to my client who was doing something differently at a different time.
All right, thank you.
Thank you.
Wait, one more, counsel. He thinks we're over. One more, gentlemen, come back to the table. The lady still has the floor.
No problem. Very briefly, Your Honor, it's also our position that the summary judgment should have been granted as to the cause of action for lack of informed consent. Dr. Maliaris clearly met her prima facie entitlement. Plaintiff never addressed that. Also, it's our position that the plaintiff failed to connect the decedent's death to the flap surgery performed by Dr. Maliaris. That was about 2 years later. The plaintiff's experts never identified a specific infection that was attributable to Dr. Maliaris's procedure. In May of 2016, he was admitted with a diagnosis of sepsis secondary to a MRSA infection. There was no indication that the MRSA infection was attributable to Dr. Maliaris. Also, the sites of the two amputations, the first below the knee and then the above the knee amputation.
And those amputations were on the knee that.
They were, yes, Your Honor, they were that
Is
leg.
Are you saying that's a coincidence?
I'm saying that there was no infection identified at the site of those amputations. So no infection, no specific infection attributable to Dr. Maliaris.
Thank you. Flatiron 30 versus Continuum Company. You may proceed.
Good afternoon, may it please the court. Christopher McCann with Cooker Marino, Wianarski and Bittens LLP for appellant the Continuum Company LLC. The order on appeal must be reversed for two reasons primarily, the appellant's constructive eviction defenses and counterclaims remanded for revived for two reasons. First of all, the court dismissed them for reasons that were invalid. The first one is that the court wrote it was undisputed that defendant did not surrender the premises, and therefore defendant's claims of eviction, actual or constructive, must fail. This isn't the law. Constructive eviction doesn't require surrender. Constructive eviction
So
claim.
how have you shown that there was that the conditions were so substantial and material to deprive your client of use and enjoyment of the premises?
Well, that's one of.
I mean, there's some annoyances. I understand lack of distancing and wearing masks, and maybe the guard is looking at pornography. But how does that really impact on the use of your space?
Well, I think that impacts pretty substantially, and the affidavit of our client's principal goes into detail, beginning at about paragraph 22 until the end. It's about 800
How
words.
did you show that you'd given any notice of those awful conditions?
Well, if you read the affidavit,
In the record, I didn't see any proof of notice of any.
well, there isn't. We don't have a copy of any notices, already written notices, but the record does reveal that the appellant, the affidavit of the appellant's principal describes disagreements between the parties, and the plaintiff didn't dispute this. So they were having disagreements about who was various responsibilities, their respective responsibilities under the lease, and these preceded the abandonment of the premises. Now, with respect to the evidence, I think what's important is that the abandonment of the premises by my client on June 16th of 2021 was never really disputed by the plaintiff. He just kind of rolled over it and moved for summary judgment, saying they never surrendered the premises, I never got the keys back. And the court ran with it and decided that because there was no surrender, there couldn't be a constructive eviction as a matter of law, and that's not the law, as we go into in our brief, and I won't waste too much time on it unless the court has any questions about that. With respect to the evidence, I think it's important that the court said that there was not any, that the claim of a constructive eviction was unsupported by any admissible evidence, and that's just not true. The affidavit of the appellant's principal is evidence. It's a sworn statement. It's relevant. It is made from personal knowledge. It is evidence, and it's admissible. So
But he says with respect to the security guard, it's based on information and belief. So I mean,
well, that's true. There is, with respect to what the nature of the material the security guard was watching, was on upon information and belief. Everything else in the entire affidavit is based on
It's the social
personal
distancing.
knowledge.
So social distancing and masking are.
The social distancing, the masking, problems with the air conditioner, problems with inadequate security generally. The information and belief was just on what the nature of what the material that the security guard was witnessed watching on his phone, and that seems a fair
I
qualification
know
to
of
make.
no case that would say this constitutes constructive eviction such that it would permit someone out of their lease. I know of no case.
Well,
based on the things that your client complains of, I know of no case that so holds.
Well, I don't know of any case that holds them specifically to each of those things, but I think taken together, they clearly make a case for constructive eviction, and it wasn't one
We
that...
would be releasing almost every tenant in the city of New York from their lease if this argument carries any water whatsoever.
Well, I don't know that that's quite right.
Oh, yes, it is quite right.
Well, I would say to the court that the
commercial leases are some of the most strict contracts that our state knows. Okay, and you know that. So I just simply don't understand why we're here.
Because it's not a contractual. This is constructive eviction is a doctrine that's independent
I know
of what the
what
contract
constructive
says.
eviction is.
Okay, so what the strictness of the contract doesn't obviate doesn't do away with the constructive eviction doctrine. Thank you.
You may proceed.
Good afternoon, Your Honors. My name is Jonathan Minikis from the law firm Cutler, Minikis and Aidman, and I am representing the plaintiff respondent. So I agree with you, Your Honor. I'm not really sure why we're here either, but I am happy to be here to address these arguments. First, with regard to this, the notion of surrender as opposed to abandonment, it does seem to me that counsel and perhaps his client are the only people that have a difficult time grappling with the fact that they're basically the same thing. In fact, this court, in at least two decisions that I could find, held in International Development Institute versus Westchester Plaza, plaintiff's claims for actual and constructive eviction fail because it never surrendered possession of the premises. In Lincoln Plaza Tenants Corp v. MDS Properties Development Corp., this court again held we also note tenant's second claim in action number 1 based on the theory of partial constructive eviction was properly dismissed as no evidence was presented that it abandoned or surrendered any possession of the premises. So this complete fiction of there being some kind of distinction has, it's inconsistent with the court's rulings. With regard to some of the queries you made, we agree that the fact that there was alleged and completely unsupported allegations that building staff was upon information and belief watching porn on his phone, or that, again, unsupported, that there were excessive fire drills, or that there was some undefined, we don't know what they're talking about, some issue with heating that wasn't promptly attended to, doesn't even say it wasn't attended to. These do not rise to constructive eviction.
How about if you combine also that with the allegation of lack of social distancing, masking, all the COVID stuff?
Well, all the COVID stuff, of course, has been rejected by the court. In my view, Your Honor, you can combine it, you can multiply it by 20. It doesn't raise to constructive eviction. Those kind of allegations just don't. But more than that, as the court found, which the appellant completely glosses over, is these allegations were unsupported. As Your Honor pointed out, there's no notice. Hey, if I'm going to declare constructive eviction on this very extensive lease, I'm going to notify the landlord at some point, hey, your employee's watching porn on his phone, or that there's not a single email, notice. And contrary to what counsel states, in our papers, we expressly state there was no notice, nobody ever complained. Nowhere in their papers does Mr. Eichner or anybody state that there was ever a complaint. There wasn't a single complaint about any of this. And there was no evidence of a surrender. They never said, hey, we're out of here. And they say the first time they alleged that they abandoned or surrendered was in the answer after this paper. And notably, they stopped paying rent in March of 2020. They allege for the first time after we brought this proceeding that they quote unquote abandoned the premises in June of 2021, which coincidentally is 1 month after we sued them. So it's a complete, absolute fiction. And again, as we point out, no evidence that they abandoned. In fact, my client, when the lease was ending, reached out to them and said to state we need access to inspect the premises. They never said, oh, we're not here anymore. He had to ask to get access. So again, there is absolutely no evidence of a constructive eviction, nothing supported, no notice, nor is there any evidence they ever abandoned or surrendered or whatever word they want to use to show that they left the premises until we sued them.
Thank you.
And again, this was a well-known real estate developer who knew better, and I can assure you would not accept this treatment from his tenants, but would know better to protect a record if there was a record, and there is none.
Thank you. You have 1 minute.
Just very quickly, since the court asked why we're here because you have a battle of affidavits. You have on one hand my client's affidavit that says there is this problem and this problem, this problem, disagreements
Right, but
between.
your client doesn't say that he ever provided them any actual notice of any of those alleged problems.
The affidavit says that there is disagreements between. It doesn't
says there are
address
disagreements. I don't know
notice
what it-
directly.
Counsel, when the court is talking, you should not be. Okay?
I don't know
Show
what it means.
respect to the court. That's all I ask. She's talking, let her finish her sentence.
I didn't mean to cut Your Honor off.
I don't know what it means to say there were disagreements. I don't recall any point where he said, I called so-and-so and said, there's a problem here because of X, or I sent an email saying X. There's nothing like that in the record, right?
There's nothing explicit like that in the record. The affidavits differ, and
Thank you. But there's nothing to differ from if you don't ever state that there was notice.
Thank you.
Shaba versus Family Home. You may proceed.
Good afternoon, Your Honors. May it please the court, Richard Barenberg from Fort Harrison on behalf of appellants. We seek a reversal of...
How many times does the court have to issue the same decision, is what I want to know. How many times? We have issued the same decision at least 3 times, and your clients keep on ignoring it. So my question to you is, why should we not sanction you?
Yes, Your Honor, and I will answer that question. The reason is because this case, we're appealing the summary judgment on the grounds that there was no jurisdiction because the claims that were certified and granted summary judgment had been resolved in the federal case. And in that sense, what's proceeding now is a double recovery because just like we're here right now, my other counsel right next to me was at the Second Circuit arguing that the federal court should be reversed. So both sides agree that there is overlap between the claims. And now 2 courts are saying both sides have to pay. So we're here because now there's a judgment that there wasn't before in the state court entitling respondents to compensation in this action, whereas before there was not. And there is also a judgment
But
in
does that change the posture? I mean, isn't it really, doesn't law of the case doctrine apply to all the claims you're making, preemption, res judicata, and as well as the jurisdictional arguments? Or are you saying that somehow that posture has changed where simple law of the case doctrine does not apply here?
I think that it changed because once there's, let me go back. I think it's changed because we raised the argument to the lower court in the summary judgment motion, and when the decision was rendered, it appeared that the lower court did not consider at all the implication on mootness in light of the federal court's judgment, because all the order says is in light of the fact that the answer was struck and no stay summary judgments granted, which I do understand, but
It means they rejected your argument, is what that means. As this court did, twice.
I do understand, Your Honor.
Apparently not,
We
because
do-
you're back.
We do think that we have never once gotten a decision from this court, or we would not be
The
here
fact
about
that you don't
mootness.
agree with the decision doesn't mean you didn't get one. And you have relief. It's called seek leave to the Court of Appeals. You don't get to keep on hitting the same ball in this court.
Yes, Your Honor, we could not seek leave but for a final judgment of the lower court. So this would be our final opportunity and first opportunity. We've tried before to seek leave, and the Court of Appeals rejected it, saying that it was improper. So this is our first opportunity to try to make the argument to the Court of Appeals that there is a mootness challenge here that the lower court never spoke of. And Your Honor can correct me, but in no decision that we've received has this court ever said anything to mootness and whether or not there's any impact on the claims for the class that wasn't certified until after the final judgment in the federal court was entered.
Thank you.
Thank you.
You'll have time. You'll have a minute on rebuttal.
Good afternoon. May it please the court. My name is LaDonna Lusher. I'm from Virginia Nambinder, and I'm here on behalf of the respondents.
What am I missing here?
I'm asking the same question.
Can you address mootness?
Absolutely, I'd love to. First of all, I'd like to point the court to page 4 of the record, which is the trial court's decision, where the trial court specifically said, upon the foregoing documents, which meant the motions that were submitted below, where the defendants had already made these arguments for the umpteenth time, for the reasons stated on the record during oral argument. The oral argument is part of the record, pages 5.0 through 5.20. Again, at the oral argument, the defendants made the exact same arguments again to the trial court. And inasmuch as defendant's answer was stricken and as there has been no stay granted of that order. So the trial court considered it all. The trial court considered their papers. The trial court considered the arguments made at oral argument. The trial court considered that they had no answer in the case, that they weren't even allowed to be making these arguments to begin with because they'd already conceded liability because they have no answer. So they couldn't even move for summary judgment to begin with, let alone oppose our motion for summary judgment. So the fact that they're saying that the trial court didn't consider these, they're saying mootness now, in their papers, their appellate papers, they said jurisdictional. They just keep repackaging it to something else. It's the same arguments. They're trying to say that because a federal court decided something that they don't like, that these individuals' claims should be precluded. I would also like to point this court to its third appeal in this case. There have been 3 appeals. And I'd also like to point out that all of the justices sitting here today have been on these different decisions, except for Justice Mazanet, who hasn't had the pleasure until today. In the last appeal, the third appeal, which is October 17th, 2023, and this was the appeal of the plaintiff's class certification decision. By this time, the federal court had already rendered both of its confirmation orders on the arbitration award, and the trial court had already considered both of them. They had been submitted specifically to the trial court before this decision at the trial court was rendered, and then before this appeal was rendered. In that decision, this court said, it's basically on pages, trying to find the reporter pages, I'm gonna say it's like 520. It was talking about how the court had already considered these things, and also that the federal court had even declined to enjoin this action from proceeding because it had found that the state courts had already ruled that the plaintiff's claims were not arbitrable, that they were allowed to proceed. This court said, Defendants cannot be heard to argue that the federal arbitrable award has a preclusive effect on the named plaintiffs or class members' claims. So not only did the trial court consider whether or not these injunctions and arbitration awards applied to not only the named plaintiffs and the class members, this court considered and found that these individuals, the named plaintiffs and the class members, can proceed with their claims, that they are not arbitrable, and that the court had the authority and not the arbitrator to decide these issues.
Thank you.
Thank you.
You have 1 minute.
Thank you, Your Honor. Just to touch quickly on the federal court's decision on the injunction, the federal court noted that because the trial court issued a footnote that purported to enjoin all class members 2 years before class certification, that out of comity, the federal court will not override or second guess whether or not that footnote is proper or enforceable, and that our proper remedy is in state court. So then we did come to your court to say that the footnote enjoining the purported class was invalid because the court had no jurisdiction over non-present, separately represented, and non-certified members who, through their union, resolved the claims. And just to opposing counsel's point, in her own application to the federal court at record 253, she states, quote, "The 2022 arbitration award purports to include the Tesha state action named plaintiffs and all other pre-2015 MOA employee punitive class members they represent." So very much so, she did believe that it did include the members in this class. So for the records, we stated in our briefs, and now we respectfully request that the lower court at least be reversed to consider whether or not mootness is appropriate. Thank you. Finally meet you. We will probably be working together on some other things, but Phil is retiring. So yeah, so we'll see where we go and how to resolve this in some way.